दोनों कोर्स हम हार चुके हैं, दोनों कोर्स हार चुके हैं, बस सब्सटेंशियल अकॉर्डिंग टू अस देयर इज सब्सटेंशियल क्वेश्चन ऑफ लॉ। आज सुन लिए ना
सवाल हो
जी
one case daily cost 13. In this case, daily order is fine.
सीरियल नंबर 13 डेली कॉस्ट
Daily cost.
क्या बात है?
ये अगर उसमें कि टैटू टू था उसमें डेली पर्सन का ऑर्डर होता है, एग्जीक्यूशन केस फाइल होता है, इसमें कुछ ऑर्डर स्ट्रिक्ट किया हुआ है।
अदर साइड कौन?
अदर साइड संजय कुमार आया फॉर्म
बुलाइए उनको, बुला के उनको बिना सुने को नहीं करना है, बुला
को
के
4 डे
ऑर्डर्स में है।
और श्री संजय प्रसाद करेंगे 4 डे
कौन
और
करेंगे?
श्री संजय प्रसाद करेंगे।
अच्छा तो
एक्चुअली उनको गिर गया इसलिए काफी इसलिए विशेष
अदर साइड को भी बुलाएंगे,
अदर साइड इन्फॉर्म स्टडी है ऑनलाइन इन्फॉर्म
उनको बुला के ये कहेंगे।
और एक परफॉर्मेंस होने वाली ये परफॉर्मेंस और एक जो
प्रोफॉर्मा तो साथ में खड़े रहेंगे ना, उनका क्या है?
नहीं
और टेस्टिंग रिस्पोंडेंट
हमको ही बोलते हैं बुला लेते हैं।
चाय पीजिए अभी चाय
From supplementary list, item 6, second April 84 of 2018.
there is no substantial question of one law. The subject is dismissed. क्या चीज़? हाँ टाइम स्टेशन
From supplementary list, item 8, second April 307 of 2016.
there is a letter from the concerned court to extend the time.
I have already decided on 7/11.
हो गया डिसाइडेड?
Status में अलग हुई तो on first page
Essay number 307 of 2016. The matter has been placed before this court at the instance of the office on the basis of a letter dated 30/10/2025 received from District and Additional Sessions Judge Romil Chatra seeking extension of time by 1 month. The learned counsel for the respondent has submitted that the final order has been passed. Final judgment has been passed by the court on 7/11/2025. No further order need be passed. The status report has been placed on it. नहीं वो एक्सटेंशन के लिए आया था, इसलिए फॉर्मल ऑर्डर करना पड़ता है। जब हो ही गया है तो
From supplementary list, this case item 1, second April 14 of 1995.
Second appeal is preferred against the judgment and decree of reversal of the 11th of the court matter. The plaintiff is the appellant. The plaintiff has instituted the suit for partition. Decided, which was decreed in favor of the plaintiff by judgment and decree dated 23/5/1991. The prayer of the plaintiff was, which is para 19 of the plaintiff.
Okay. Suit is of 89.
Second appeal was admitted by order dated 21/11/1995. On the following substantial questions of law. whether even after adoption of the defendant, Man Kumari, Puneet Chaudhary and his two sons, namely the plaintiff and the defendant, continue to be in occupation of the suit premises as the members of the joint Hindu family. Second, whether the plaintiff is entitled to any share in it. Criminal liberty.
You want to place a plate?
Also, court the relief was
Relief is mentioned in para 1 of the judgment.
speak
That will be
that
sufficient.
on adjudication of preliminary decree for partition of half share of the plaintiff in the suit property schedule B below be passed. B. The plaintiff's takta of half share in the suit property schedule B below be carved out and separated from the takta of the plaintiff by appointment of a survey knowing advocate commissioner, and the plaintiff be put in half possession over his takta so carved out through court. Cost of the suit and interest thereon pendentalized until the realization of the same be awarded to the plaintiff against the defendant. The facts of the case was that one Kumari was married to Kali Charan Bhagat. Kali Charan Bhagat had two wives.
राकेश के पास जो है कल का टाइप किया हुआ कुछ है उनको बोलिए बेटा. Yes, yesterday we have seen the table. Yes. Two sisters,
Two sisters.
Man Kumari and Kaushal Kumari.
Man Kumari was married to Kali Charan Bhagat. Kaushal Kumari was married to Bhagwat Prasad Bhagat. Now, Man Kumari did not have any issue of her own. And from the previous marriage of Kali Charan Bhagat, there was one daughter, Jamuna Devi.
How do you say which is previous marriage?
Well, because it is embedded that after the death, he claimed that after the death, he remarried.
Whose death? After the death of previous wife, he remarried to Man Kumari.
He remarried.
So first wife had children.
No, yes,
First
First
wife
wife-
had a daughter.
daughter, Jamuna Devi. And that is a para 2 of the claim.
That's okay. It is very
Jamuna
clear.
Devi, and Jamuna Devi had a daughter, Savitri Devi.
That's it.
Savitri Devi was married to Natuni Swami. And from their wedlock, the plaintiff and defendant wedlock.
That's it. We have recorded it yesterday.
Just to recapitulate.
Man Kumari had no issue. She adopted Dwarka.
Sure.
So tell us how the property of Man Kumari will go to Vishwanath.
The adoption, purported adoption, it was initially challenged. And there was a decree that the adoption is clear. Thereafter, they prepared a first appeal before the honorable court. And during the pendency of the first appeal, the parties came to compromise. And in the compromise, it was decided that Bhagwat Prasad Bhagat, who was husband of Kaushal Bhagat, would get some share out of the property, and then he would recognize the adoption as valid. That the defendant is the adopted son of Man.
That was the bargain.
And thereafter, the suit, the appeal was dismissed. The suit, the order passed in the suit remained as it is.
Dismiss means it was disposed of in terms of compromise, no?
But the board uses dismissed.
Maybe that we will not pick up one word.
That may be, but I'm not on
There
that.
was a compromise.
Because I'm not going on the validity or whatever with regard to
Adoption is valid. Do
Adoption.
you want to argue that adoption is invalid?
No, I'm on the point that the adoption was not acted upon. As they remained in the joint family property, Dwarka Prasad Bhagat continued to be in the part of the family. The ties were never severed, He performed all the obligations of the elder son, the Mukhagni ceremony of his father, the Shraddh ceremony of his father. Everything was carried out and exercised by Dwarka Prasad Maharaj, and therefore the property remained intact. And the adoption deed was not acted upon. And that
What is the consequence of adoption deed not acted upon?
Ma'am,
Does it nullify the adoption?
my lord,
Adoption is a past transaction.
the principle of adoption is that the every ties with the natural family, the biological family, get severed.
Suppose there is an adoption, and by a registered document this adoption was there. So that adoption was also subject matter of challenge and everything happened in connection with that. You being the plaintiff, the adoption as such, the validity of adoption as such is not under challenge.
No, it is
Not under challenge.
No.
So even if an adopted son performs many activities with respect to his biological father, can he go back to the family?
The ties severs. He cannot perform.
You see, a person can perform last rites even of his neighbor. There is no legal bar,
Correct.
right? There is no legal bar,
About
right? Even to third persons, right? A person can perform many rites, many last rites can be performed. There is no doubt. There are so many people who are moving away, they don't come back to attend their parents. Then their near friends, dear friends, they perform the last rites. They do not leave the dead body there itself. Right?
But it is, in my humble submission, it is when there is nobody to perform the last rites.
Need not be. You see, really because a person
Vishwanath
is
Prasad.
performing the. What is your case? Do you say that the adoption was not acted upon or adoption is
Yes,
invalid?
Yes, sir. That is the substantial.
Adoption?
I am confining my argument.
No, we will see your case. No, we will see that. What was your case? You are the plaintiff.
Mine.
You read your case from the plaintiff.
If I may refer to the relevant paragraph 13, my lord.
You read it from the plaintiff. What was your case?
That for all intent purposes, the plaintiff and the defendant contested the said suit.
No,
and-
plaint. Where is your plaint?
I'm reading out the plaint.
Plaint?
Paragraph 13.
No. Read it from the plaint. What was your case?
शुरू
The
से-
plaint. आप अपने plaint का copy निकालिए.
हाँ, plaint सी देखें।
कौन सा paragraph number
13 number.
of the plaint?
Yes. That for all intent purposes, the plaintiff and defendant contested the said suit and the appeal with a clear and mutual understanding that each plaintiff and the defendant shall be entitled equally to the subject matter of the said suit and the appeal. In legal parlance, the suit property was thrown to the said joint family's law. That the said appeal and any compromise according to which the land and the premises schedule B below was given to the defendant who accepted the same for and on behalf of the plaintiff as well as the plaintiff and the defendant always treated the same as their joint property and both the parties are residing there.
You are treating. This is not about adoption. You say the property was thrown in joint family.
But the case is in respect of the property itself. Property is an aspect of the adoption also. This is what they are also trying to make out. And this is what the learned first appellate court has held. Learned first appellate court, while reversing the findings made by the trial court upon evidences, has referred to the law, well settled law, that all the ties are
A
severed.
property which is not a joint family property. This property was originally not a joint family property because it belonged exclusively to this lady. Mankumari, it is not a joint family property. Right? How this property gets transferred into a joint family?
Not upon development.
How?
Because
How
they-
will it get transferred to a joint family will devolve upon the legal heirs and successors. But how a property which is not a joint family property can form a part of the joint family property?
After the death of the absolute owner, presumably who has acquired the property, that was a self-acquired property.
Yes.
If she dies interstate,
Yes.
the property would devolve
How?
in view of the succession.
The property will devolve upon the adopted son.
Madam,
The question when there is a class 1 here, It will not go to the class 2 here.
Madam, that is the point. That is the point. That there was an adoption, but it was never acted upon.
Where
because
have you said that the adoption deed was never acted upon and therefore the adoption stands nullified?
the property was thrown to the family
Property is another thing. Property is another thing. You see, two brothers in the family, right? There is inter-se adoption. One brother gives his child as in adoption to another brother, right? They constitute one family. But when the other brother would die, the property will devolve upon his class 1 here. It will not go to his brother.
when the adoption is acted upon.
Where
When it
have
is
you said?
supervised.
Therefore, devolution of property is different from the story of adoption. Where have you stated that the adoption was never acted upon and therefore the adoption has no value?
That is not directly explicitly said. But
Even
in
indirectly it is
paragraph
not said.
30, in paragraph 30 it is inherently there, because otherwise if the adoption deed would have been acted upon, it could not be thrown to the joint family of the joint
It
property.
is not like this. ये आप सेकेंड अपील में बहस कर रहे हैं, इतना आप कहाँ से ये सब बहस कर रहे हैं?
My lord, what will happen when the adoption deed is not acted upon? I want to put a question to myself.
Show me that it is not acted
Because
upon.
why I am
No.
saying, yes, my lord, why I am saying that in the evidences out of the 7 plaintiff witnesses, 4 have categorically stated that all the ceremonies were performed by the elder son, Dwarka Prasad Bhagat, in respect of the death
अरे
of
भाई,
the
आप हमको बताइए, वो तो भाई की बात कर रहे हैं. Because they are in the same family. You please appreciate this. Two brothers, one brother's son is given to the other brother as in adoption. Suppose he performs the last rites of his uncle now, right? You say,
He cannot.
who says legally he cannot?
Because all the ties
Show me under which law you say that a person cannot perform a legal rights.
एक बार बस फर्स्ट एपलेट कोड का सिर्फ जो रेलेवेंट पोर्शन है बस पढ़ दे रहे हैं.
या सोसाइटल नॉर्म से मत
सोसाइटल
चलिए,
नॉर्म से क्या
लीगल नॉर्म से चलिए.
मानो हम बस खाली पढ़ दे रहे हैं. हाँ, उसमें जो सेटल्ड प्रिंसिपल उन्होंने जो कोट किया है पैरा 24 में, it is a settled principle of Hindu law that by adoption the boy is completely removed from the natural family as regards of civil rights and obligations. He is so completely removed that he has not even to observe pollution. It is in respect of the death, on the birth and death of any member of the family of his birth. The adopted son loses his rights in the co-parental property, and his natural family cannot inherit from him, nor is he liable for their deaths. He also ceases to perform funeral ceremonies for those of his family for whom he would otherwise have offered oblations, and he loses all right of inheritance as completely as if he had never been born in his natural family. Now there is a categorical finding by the right tribunal that he has performed this. Perverse.
That is why there is an appellate court statute.
But appellate court has not considered those evidences.
See, if there is a fight between two people as to who would perform the last rites, there can be an adjudication to that. But merely because he has performed the last rite of his biological father, that will not nullify the adoption. Once the adoption is done, it is done for all times to come. Unless his biological father again undertakes a ceremony of adoption and gets him in his family.
That is what I am also saying, madam.
There
He
is no such
cannot-
ceremony.
Civil rights get severed. He cannot.
He does not have.
It was never acted upon.
Please appreciate. He does not have a right to perform. Right? You in the family you are seeing that girls are performing the last rites in spite of the son. In spite of the son.
Yes.
Right?
That
Yeah.
happens in this society.
Even the cousins are performing the last rites in spite of biological sons. It is happening. Merely because a person has performed last rite of his biological father, that will not annul the adoption.
That will not annul the adoption when the adoption is acted upon. Here, nothing has acted upon. They remain in the same family. The property remained in the same family. He performed discharge
His
all the
status-
duties of the
His
elder brother.
status as class 1 here has not changed of adopted mother.
month to month. No, not
You show me that his status as class 1 here has changed.
not very.
Show me some law that his status as class 1 here will cease to exist merely because he has performed the last rite of his biological father.
But the law is not direct on that. The law is that all the ties get severed and engrafted into the.
बोल तो रहे हैं पड़ोसी भी कर सकता है लास्ट राइट.
ठीक है ना, तो राइट से ना अक्रू कर जाएगा प्रॉपर्टी में, कर सकता है.
लास्ट राइट्स परफॉर्म करने से इनहेरिटेंस नहीं अक्रू करता.
हम ये दिखाना चाह रहे हैं कि that
अच्छा
remain
समझ
a
गया
family
आपके पास.
property.
ठीक
That remain a family property. But trial court has given a consideration on that.
So you are relying upon para number?
Para number of the trial court?
No, of the claim
Para number
30.
13, 14.
The learned counsel for the applicant has referred to paragraph 13 and 14 of the plate to submit that the adoption was never acted upon and the suit property was thrown in the joint family property of the parties. Para 13 and 14 of the plaint is quoted as a on the plaint.
Para 9 of the trial court judgment starts to deal with the issue of adoption vis-a-vis the rights performed by the defendant. That has been dealt at para 9.
He has referred to paragraph 9 of the trial court judgment.
Trial court judgment. That's it. May I read, ma'am?
Just a minute. This is a part of your submission.
Ma'am, उसके बाद consideration needs.
उसके बाद
Next page 8 में longish time.
you did para 9.
पूरा पढ़ लो.
Of course, पूरा.
Apart from this, it has been also argued on behalf of the plaintiff that admittedly the adoption of the defendant has not been accepted by judgment and decree passed in title suit number 18 of 1947. In the decree passed in title, in the circumstances, the effect of invalid adoption will be that the defendant neither loses anything nor gains anything, being adopted son of month to month. In this reference, our attention towards para 220 of the Chinese Hindu law and Mullah's Hindu law section 510 and 511 has been drawn. Thus, according to the plaintiff, on the basis of the above facts, it has been argued that in legal parlance it would be presumed that the property acquired by the defendant Dwarka Prasad has been thrown into the joint Hindu family of the plaintiff and defendant along with their father. In the reply, it has been argued on behalf of defendant that from Exhibit H, that is certified copy of the compromise petition filed in first appeal, 11 of 40A, it will appear that
Just a moment. It will be presumed that the property acquired by Dwarka Prasad. This property was acquired by Dwarka Prasad as adopted son.
Okay.
Yes, please. Carry on.
it will appear that the compromise contesting party has accepted defendant Dwarka Prasad Bhagat as adopted son of month to month. On perusal of the compromise petition, I find that the contesting party by para A has accepted the defendant Dwarka Prasad Bhagat as adopted son of Kali Charan Bhagat. And in this circumstance, I am of the opinion that the argument advanced by plaintiff's lawyers in this respect cannot be accepted. So far, other aspect of the argument advanced by both the parties will be considered on the evidence available on the records. In
So
evidence,
this plea was rejected
this plea was
by the trial court.
by the judge. No.
This argument that
This argument
it
was-
goes back to the family
Family.
is rejected.
It starts with that it was an invalid adoption.
No. You see,
Refer me
thus
to
according the
invalid-
property acquired by defendant Dwarka Prasad has been thrown into the joint family, this argument has been rejected.
on the basis
Whatever
that
be the basis, but
No,
this
because-
argument has been rejected by the learned tribe.
my understanding, but on madam, may I just summarize for a moment. On the basis that the adoption deed is invalid. In evidence, most of
That is not the basis. You are reading into it.
about
आगे पढ़िए. So far as other aspect,
so far as other aspect argument advanced by both the parties will be considered on the evidence available on the records. In evidence, most of the witnesses of the plaintiff and plaintiff himself has said that it was Dwarika Prasad who has performed last ceremony and Mukhagni and Shraddh of the natural father Nathuni Chaudhary. This fact has not been denied by the defendant in his evidence. In the circumstances, it will be treated as admission in this aspect. In these circumstances, argument advanced on behalf of the plaintiff that it is a strong circumstance to presume that though the defendant has been adopted by Mankumari, he is continued to be the member of joint Hindu family consisting of plaintiff and the defendant as well as their father. So this was accepted on the basis that it was
they themselves constituted a joint family because Mankumari was the common ancestor. After all, she was the stepmother. Stepmother. भाई अगर एक वाइफ की डेथ हो जाती है और फैमिली में दूसरी वाइफ आ जाती है, she forms a part of the family. But the point is whether her individual property will become a joint family property.
if he performs the right.
Even if you forget about it. भाई अगर घर में
Presence of
अगर
Hindu
किसी भी हिंदू मेल की 2 या 5 शादी हो जाती है one after another, it is not a case that she is an illegitimate or illegal wife, right? That is not the case. Once she enters into the family as a married lady, right, she will have all the rights of a joint family. She will have a right for maintenance. She will have so many rights, right? Under the provisions of Hindu law, whatever is the right of a wife, she will have all those rights. So there is a joint family. There is no doubt on that. There is a joint family.
So after her death, if she dies intestate.
No, she did not die intestate. She died with a son. She died with an adopted son.
Any will or bequeathing her
Need
property to anybody.
Not
because-
required. Once she adopts, the property will devolve accordingly, according to succession. He is the class 1 here. It will not go to the class 2 here.
Although this is the finding by the learned trial court, which has been reversed by the learned first appeal.
Now let's see. What is the finding of the learned first appellate court in connection with this?
Para 25. Para 25. Page 11. Appellate. Page 11.
Yes, paragraph.
According to the case of the plaintiff respondent, as stated at para 5 of the claim, the adoption in question was made in or about the year 1944. In that view of the matter, in the face of the above legal principle on adoption of a Hindu boy, the plaintiff respondent is completely stopped from contending and agitating that even after adoption, defendant appellant Dwarka Prasad Bhagat continued to be a member of his joint family, the karta of which was his father Nathuni Chaudhary, as he has tried to make out a case in his plaint. So evidences were not considered, which were considered by the trial while reversing this finding.
There is not exactly a reversal of that kind. You see, when we are in second appealing and once a substantial question of law is framed, we will see how the facts they arise. They are in the same family. There is no doubt that they are in the same family.
But the evidence.
And that finding has not been reversed.
The evidences which deposition in respect of, it is my humble summation, in respect of the ceremonies carried by the elders has not been taken into consideration. That has not been taken into consideration. Had it been the case that the defendant would have
एक
been.
भेजा है, दूसरा नहीं भेजा है. दो ऑर्डर भेजे थे. उनको बोलिए जो कल काम करने बोले थे. I have it.
Where is the evidences of the parties?
What evidence do you want?
There is a categorical statement that he has performed all the rights.
Yes,
Being a
yes.
son.
Let's accept it. He has performed all the rights. There is no dispute on that. It is an admitted fact. For that, we don't even need to see the judgment. There is a finding that it is an admitted fact that he performed the last rites of his biological father.
So whether after the effect of the valid adoption, can he perform the last rites of his biological father?
Merely because he has committed a wrong by performing the last rites of his biological father. Does it amount to annulment of adoption?
When it is supported by the fact that the possession of both the brothers remained and
Possession will not give you title.
I understand, madam. I totally understand, but it has a corroborative effect. So far,
It is not your
so
case
far
that
the
you
effect
have.
of adoption is concerned. Had it been the case that
You just tell us. Suppose there is an adopted son and who does not perform the last rites of his adopted parents. Does he ceases to be an adopted son?
no,
No. Similarly, if there is an adopted son and he performs his last rites of his biological father, does he ceases to be the adopted son?
in the facts of the case, yes. Why I am saying this? Because
Show me some law, some judgment on this, that if a person goes and performs after adoption, if he goes and performs the last rites of his biological father, the adoption stands null.
he has not only performed last rites, he has continued श्राप भी इन्होंने किया है.
सभी कुछ किया होगा.
श्राप भी
हम
इन्होंने
मान
किया
लेते हैं सब कुछ
तो
किया.
फिर सिविलिटी कहाँ से आएगा हमारे?
नहीं,
सिविल
आप-
कहाँ हो रहा है टाइम्स? बायोलॉजिकल जब की यंगर ब्रदर है.
आप हमको कुछ लॉ दिखाइए, है ना? अभी कोई जूरिस्प्रूडेंस पे हम लोग बहस नहीं कर रहे हैं. आप लॉ दिखाइए कि the adoption gets nullified by virtue of this act, by virtue of the conduct of the adopted son. Show me. By virtue of the conduct of the adopted son, the adoption is nullified.
इस पॉइंट पे
नहीं, रिसर्च तो
रिसर्च.
ऐसा कोई जजमेंट हो ही नहीं सकता. ऐसा कोई जजमेंट हो नहीं सकता. Once an adoption is always an adoption.
But it has to be performed.
What
उसको
perform?
रखा वो sheet.
Adoption नहीं, sheet नहीं है वो. It is a registered document.
That's
That's not
but nobody has acted under it. That is why
the deed of adoption is not under challenge.
No, it is not under.
Then that is a registered document.
That is a registered
Under the provision of law, there is a presumption in connection with its correctness, right? जब वो question में ही नहीं है, when it is not under question, then under such circumstances, how can you argue this? It is not possible.
Exhibit G दिखा देते हैं मतलब जो ऑनरेबल पटना हाई कोर्ट ने डिसाइड जो कॉम्प्रोमाइज पिटीशन में डिसाइड किया. Exhibit G. Exhibit G is order dated 5/12/1947. Defendants appearing 1 and 2 and plaintiff responding number 1 have 5 days application for disposal of the appeal on compromise. The parties to the compromise petition are all majors. We direct that the appeal as between the appellants and the plaintiff respondent number 1 be disposed of on the terms incorporated in the compromise petition, which will form part of the decree on this court. The appeal is not pressed as against the remaining respondents 2 and 3 and is dismissed without notice. So, my lord, what will happen to the order, the judgment passed by the original court, nullifying the adoption. However, my scope of argument is very limited because that is not the substantial question. I am not on that particular, but it will have some bearing.
Just like any ability to compromise that was in the same judgment. Like any ability to compromise.
Yes, I'm saying.
A.
You please take your arguments when you
Yes,
are asked.
I'm sorry. Yes, please. Let him answer.
Make a full-fledged argument.
Are you correct, sir? Yes,
The full-fledged must be.
you are exact.
ठीक है, we have seen the learned counsel has referred to exhibit. The learned counsel for the appellant has referred to paragraph 9 of the trial court's judgment and has submitted that the same finding has been reversed by the learned first appellate court by paragraph number 29.
First 24. Just 24. Paragraph 25.
By paragraph 25 of the judgment without discussing the materials on it. The learned counsel has then referred to exhibit G, which is the order passed in first appeal number 11 of 1949 and has submitted that the appeal against the judgment passed in the title suit has been practically dismissed. In the earlier title suit has been practically dismissed.
The compromise petition, by point B and C, madam, relinquishes the portion of the adopted son's property in favor of Bhagwat Prasad. Had it been the case that the adoption would have been proper, legal and acted upon, he
Raise
would
it.
not have relinquished. It is on the pretext that the plaintiff respondent Bhagwat Prasad Bhagat accepts defendant number 1 Dwarka Prasad as the adopted son of Panchal. He has accepted. The court has nullified and set aside the adoption.
That's right. Then B.
B. That all right, claim and title of defendant number 2, Musamad Mankumari, holding number so and so, new holding number 3 and 15, ward number 3 of Girirdi Municipality, PS Girirdi, District of Hazaribagh, will vest in the defendant number 1, Dwarka Prasad Bhagat, and plaintiff Bhagwat Prasad Bhagat. Both.
In this particular case, this compromise was between
Bhagwat Prasad Bhagat, he was wife of Kushal Kumar, sister of Mal, and Mal Kumari adopted Dwarka Prasad. Against that adoption deed, the suit was laid.
who was defendant number 2? Who was defendant number 3? And who was defendant number 2?
द्वारका प्रसाद भगत. बाबू भागवत प्रसाद. Defendants were Dwarka Prasad, Man Kumari, alias Man Kumari defendants.
No, there were 3 defendants now.
There are 4 defendants.
In the earlier title suit.
Sudarshan Chakra Prasad Bhagat and Mahadev Bhagat. They were the plaintiff. And the defendants was Dwarka Prasad, Man Kumari.
Who were the plaintiffs already in this particular case?
Bhagwat Prasad Bhagat.
And Bhagwat Prasad Bhagat is totally alien to the family.
Yes.
He is
Although he
the
has been exempt share.
sister of
Husband of Kaushal Kumari.
husband of
कुमारी का दोनों ही है
हाँ?
फैमिली में है ही नहीं
मन कुमारी के बहन का husband.
मन कुमारी तो full sister है.
हाँ, मन कुमारी और कौशल कुमारी.
They are full sisters.
Full sister.
मन कुमारी के तो मतलब एकदम ही अलग फैमिली के. Bhagwat Prasad is totally from a different family.
And he challenged the adoption.
He challenged adoption.
And there was set
And
aside.
there was a compromise between a third party and the adopted parents. थर्ड पार्टी हो गए ना ये तो फैमिली में तो फैमिली मेंबर तो नहीं बनेंगे हिंदू लॉ के अनुसार.
But there was a compromise between Man Kumari, the defendant number 1, Dwarka Prasad.
Who was the plaintiff in this case?
In
The
this
suit.
suit, Bhagwat Prasad Bhagat.
This was title suit number
18 of 47.
18 of 1947.
18 or 47. ये थे प्लेंटिफ. डिफेंडेंट कौन कौन थे?
Plaintiff 2 है, 3 इसमें, according to the appellate जो compromise उन्होंने फाइल किया है, versus the बाबू भागवत प्रसाद, just on the next page, compromise हुआ उसके अगले पेज पे compromise petition,
हाँ.
उसमें verses में है first में बाबू प्रसाद भगत plaintiff and महादेव.
ये कहाँ से बन गया? Exhibit H.
Exhibit G के हाँ H जो compromise है.
H में कहाँ से आता है?
First page,
फर्स्ट पेज में तो इन द मैटर ऑफ कॉम्प्रोमाइज.
हाँ उसमें पार्टी है
नहीं पार्टीज में नहीं दिया हुआ है इसमें. द्वारका प्रसाद एंड अदर्स वर्सेस भागवत प्रसाद एंड अदर्स करके दिया हुआ है.
मैडम उसमें भी होगा सब्सिक्वेंटली इसमें भी वही चीज़ है.
नहीं ये दोनों टैली नहीं करते. ये डॉक्यूमेंट यहाँ एग्जिबिट नहीं है. Exhibit D.
Compromise petition में वो party arrangement.
Exhibit D is just one page, the order.
हाँ वो order.
ठीक है, उसके बाद कॉम्प्रोमाइज पिटीशन है जिसमें पार्टी पोजीशन नहीं है.
नहीं.
ये एग्जिबिट H है. एग्जिबिट G का जो आप बोल रहे हैं ना वो नहीं है उसमें खाली वही है कॉम्प्रोमाइज. ये कॉम्प्रोमाइज डिक्री जो है ना जो अल्टीमेटली जो पार्टी पोजीशन के साथ डिक्री बनी है वो नहीं है एग्जिबिट से.
Compromise petition.
आपको दिखाती हूँ.
टाइटल सूट में देखेंगे यूनिवर्सिटी टाइटल सूट का जजमेंट में तो इसमें पार्टी पोजीशन दिया है लेकिन ये सब डिपेंडेंट शो कर रहा है. सुदर्शन चक्र प्रसाद भगत और महादेव प्रसाद भगत ये भी एग्जिबिट हुआ है टाइटल सूट.
प्लेंटिफ में कौन कौन थे?
प्लेंटिफ में केवल भागवत प्रसाद शो कर रहा है इसमें टाइटल सूट के जजमेंट में.
और डिफेंडेंट कौन कौन थे?
द्वारिका प्रसाद भगत,
हाँ.
उस्मान मान कुमारी, थर्ड सुदर्शन चक्र प्रसाद भगत, फोर्थ महादेव प्रसाद भगत. ट्रायल कोर्ट के जजमेंट में. और इनका पार्टी पोजीशन डिफेंडेंट शो कर रहा है चारों का.
बाकी प्रोफॉर्मा होंगे ना? बाकी प्रोफॉर्मा होंगे.
दिख नहीं रहा.
द्वारका प्रसाद और मान कुमारी इन्हीं लोगों ने अपील फाइल किया. Plaintiff was the respondent, and then the other two were pro forma.
It is not showing in the document. I cannot say.
लेकिन ये रिकॉर्ड से ये डॉक्यूमेंट नहीं है. The learned counsel for the appellant has submitted that in title suit number 18 of 47 filed by Bhagwat Prasad Bhagat.
इससे भी क्लियर हो रहा था यहाँ पे भी खाली बुजुर्ग का क्लियरेंस के लिए बता दे रहे हैं. द्वारिका प्रसाद एंड मान कुमारी were the appellants in the appellate court. Babu Prasad Bhagat was the plaintiff and thereafter it is showing Sudarshan Chakra and Mahadev were the defendants in the court below.
The suit was filed by Bhagwat Prasad Bhagat against 4 defendants: Dwarka Prasad Bhagat, Man Kumari, Sudarshan Prasad Bhagat, and Mahadev Prasad Bhagat.
Sudarshan Chakra.
Sudarshan Chakra Bhagat and Mahadev
Mahadev Prasad Bhagat.
Mahadev Prasad Bhagat.
Only Mahadev.
And in the suit, the registered adoption deed was set aside. He submits that appeal was filed by the defendant number 1 and 2, which was numbered as First Appeal 11 of 1949, which ended in a compromise. The respondent number 2 and 3 in the said compromise were the pro forma defendants in the suit. है ना? Pro forma defendants होंगे.
What do you think? I cannot say. What do you think?
Were 4 defendants in the suit. He has submitted that as per the compromise petition, the plaintiff Bhagwat Prasad Bhagat accepted that defendant number 1, that is Dwarka Prasad Bhagat, was the adopted son of Kalicharan, And further, it was agreed that all the right, name and title of defendant number 2, Mausamar Mankumari, with respect to her property, which is scheduled B property in the present case, will vest in defendant number 1, that is Dwarka Prasad, and also the plaintiff Bhagwat Prasad Bhagat. And then it was further stipulated that the property of Mankumari was divided between Dwarka Prasad Bhagat and Bhagwat Prasad Bhagat amongst themselves. And the portion to the west fell in the share of Dwarka Prasad Bhagat, and the portion in the east fell to the share of Bhagwat Prasad Bhagat. And further, Bhagwat Prasad Bhagat undertook to redeem the mortgage bond of rupees 550 executed in favor of Chandra Shah by Dwarka Bhagat Prasad over the state house, which fell into the share of Bhagwat Prasad Bhagat. Ramchandra Shah. It was also agreed that the parties would get their names mutated in the municipal register. And neither parties will raise objection with respect to each other's share. Bhagwat Prasad is a party in this suit. So the property was divided between Bhagwat Prasad and Dwarka Prasad.
Upon compromise. Upon compromise. After the validity, after the.
How do you take advantage of this compromise? Because as per this compromise, the property never fell on you.
I take advantage on two elements. First, that the adoption deed was set aside. That finding remained intact, was not disturbed by the Honorable Patna. That is not.
That is in terms of compromise. He accepted that he was the plaintiff. The plaintiff respondent accepts defendant number 1 as adopted son of Kali Charan Bhagat. This is his first step.
So it has been accepted by Bhagwat Prasad.
He was the person who challenged it. So it was accepted.
But it has already, stood the scrutiny of the learned
You
court.
see,
There was a finding that it is not proper.
it was not a judgment in red. It was a judgment in personnel. If the plaintiff says that I accept the adoption, the matter ends. The plaintiff says that I accept the adoption.
So the finding given by the learned trial court would be rendered redundant in view of the compromise.
Naturally, because a person who challenged the deed of adoption, in compromise he says that I accept the adoption. Simple.
But what will happen with the finding by the trial court? That is my argument. that it has some bearing. And secondly, Bhagwat Prasad has recognized. I mean, it's my submission that he has recognized, and therefore it cannot hold the validity in the eye of law.
The
In
learned
the eye
counsel
of-
for the appellant has submitted that in the compromise, the sole plaintiff Bhagwat Prasad Bhagat had accepted that the defendant number one in that case, namely Dwarka Prasad Bhagat, was the adopted son of Kalicharan Bhagat. The same will have no bearing on the finding recorded by the learned trial court that the adoption was invalid in the eyes of law. He submits that merely because the plaintiff who had challenged the deed of adoption accepts that there was adoption in compromise, the same will not nullify the finding of the learned trial.
यही है। And एक बस effect of invalid adoption क्या होगा ट्रायल कोर्ट के भी जजमेंट
As a sequel to the aforesaid judgment, he has submitted that the adoption, the effect of adoption, effect of invalid adoption is क्या है?
As a general rule, it may be laid down that where there has been an adoption in form, but such adoption is invalid, the adopted son does not acquire any rights in the adopted funds, nor does he forfeit his rights in the national trust.
He submits that as a result of the fact that the adoption was invalid, the status of Dwarka Prasad Bhagat continued to be in his own family of biological father. And therefore he cannot acquire any right, title and interest in the property of Manikumari
Exclusive.
by virtue of adoption.
It has been quoted in the Mullah's Hindu law.
There is no doubt on that. The point is whether the court will hold that the adoption is invalid. Judgment कौन सा है आपके?
बस वही रिवर्सल पर है मतलब
नहीं तो आप जजमेंट साइड के हैं तो साइड तो करेंगे ना जजमेंट.
बस वो
दीजिए judgment. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court.
judgment
क्या?
the principles of
अभी आप बोल रहे थे there is a judgment recited.
judgment that's a section in prior to enactment of the 56 Act. How the customary law would work is what would be the effect of invalid adoption.
He has relied upon the principles of Hindu law
Hindu law
Book.
by law.
by Mullah. Edition कौन सा है?
507 24th edition.
24th edition, page number 507.
That is a section. Sections.
Principal numbers.
Page 730.
700
30.
730.
7.
आप वो जो प्रिंट जो दे रहे थे वही दीजिएगा.
वो
किताब पर
पुराना
क्या है?
एडिशन का है जो कि जजमेंट में quoted है. उसमें एडिशन
वो भी दे दीजिए.
Single paper में 50 edition.
He has relied upon 24th edition of Hindu law by Mullah at page 713. Which deals with effect of invalid adoption. इसको पेज को flip कर दीजिए. Okay, what else? That's all.
Possession is admitted. That is not even the substantive question of law. And in that regard, if one also pleases, I am entitled to the half share of the property of the state of Jharkhand, which has revolved from
The learned council submits that as the adoption, if the adoption goes, then under such circumstances, both the parties, the plaintiff and the defendant, were entitled to half share of the suit property. Still,
Yes. Plus, only for the first point, the limitation for if a adoption is also invalid, it has to be declared by court of law under section 511 of the Mula Sindhu law. 511. The first answer to this question, what will be the effect of invalid adoption on a declaration is required to be sought for by the court. From the court.
the learned counsel for the respondent has referred to 22nd edition of Hindu Law by Mulla at page number 707 and has
Section 511. Limitation.
submitted that the period of limitation to obtain a declaration that the adoption is valid or never took place is 6 years from the date on which the alleged adoption becomes known to the plaintiff. The learned counsel submits that the registered deed of adoption in the present case has still not been satisfied.
This was only to answer to this. Now I am giving
Yes,
the
sir.
other. I am
Quickly.
now submitting my other points. Now, Lord, the question that was the Bhagavad Prasad. He was also one of the relative of Kalicharan and this Manakumari.
Yes,
This is from the title suit judgment itself.
that's right. We have seen
There
that.
were other properties also. Therefore, he challenged the adoption that the other properties should not devolve upon this Dwarka Prasad Bhagat. Therefore, he challenged the adoption. Sir, now may I?
Sir, आपस में भी please बात मत करिए. It is disturbing.
I'm just saying you know.
Now, it is said that the Bhagat Prasad was one of the family member of husband of Mahatma, that is the Kalicharan, and there were other properties also in dispute between them. Therefore, he filed this title suit
Bhagwat Prasad was not a family member of Kali.
as per the judgment, as I have gone through this judgment, he was one of the family members of the Kalicharan Bhagat also. The son of brother of he is the Bhagwat Prasad was the son of uncle of Kalicharan Bhagat.
So,
One descendant of
extended.
Yes, ma'am, of the extended family. This is the answer to the lordship's query, that this is the exhibit document. Therefore, I am just referring to that.
Which is this exhibit?
The title should not 18 of 1947. This is also an exhibit document. इसमें आया हुआ है.
This is exhibit 10.
Yes. So he challenged the adoption deed initially. Thereafter, he accepted the adoption deed as per the compromise. Therefore, it cannot be said that the adoption was held invalid or it was set aside. May I get the book back? Not I just want to refer that thing also.
वापस दे दो.
Now, Lords, what is the purpose of a status of a adopted child? Section 11 and 12 of the Adoption Hindu Adoption and Maintenance Act clarifies the position.
The learned counsel for the respondent has submitted that the judgment of title suit number 18 of 1947 is on record and marked as exhibit 10, and upon perusal of the state judgment, it appears that Kalicharan Bhagat and Bhagwat Prasad Bhagat were also distantly related.
And there were dispute of other properties also.
And there were dispute of other properties also.
And he challenged
The learned counsel has submitted that Bhagwat Prasad Bhagat was the sole plaintiff who challenged the deed of adoption in the suit, and at the stage of compromise, he accepted the adoption as valid, and therefore it cannot be said that the adoption is invalid by any stretch of
or
imagination,
it was set aside by him.
or it was set aside by any court of law.
Now the status of adopted child in section 11 and 12 of the Hindu Adoption and Maintenance Act says that the adopted child is once adopted, he is to be considered as a son of the adopted father.
The
Only
consequence
section
of
16
adoption has been mentioned in section 11 and 12 of the Hindu Adoption and Maintenance Act, and as per this provision, the adopted child acquires the status of child in the adoptive family.
Section 16 presumes to be valid unless it is proved otherwise.
The learned counsel has also submitted that as per section 16 of the Hindu Adoption and Maintenance Act, a registered deed of adoption is valid unless it is proved to be invalid. He has also submitted that the adoption deed is not under challenge in the present proceedings. The present proceedings arises out of a partition suit.
Limitation I have already shown to your Lordship. Now, Lord, your Lordship have a hearing notes in second appeal number. It has not yet been reported notes, but I have taken note of it. In second appeal number 493 of 18, in the case of Pavan Rao versus Shanti Kumar, your Lordships have upheld this proposition of law. Relying upon 1969 2 SCC 544, Srimati Sitabai and another versus Ramchandra.
Which paragraph are you referring to?
Paragraph number 8 of the same agreement.
क्या बोले इसका?
Relying upon such judgment, it has been held that the true effect and interpretation of section 11 and 12 of the Act of 1956 is that when either of the spouse adopts a child, all the ties of the child in the family of his or her birth becomes completely severed, and these are all replaced by those treated by adoption in the adopted family.
He has relied upon the judgment passed by this court in SC number 493 of 2018, in which a reference has been made to judgment passed, judgment reported in bracket 1969 bracket close to ACC 554, and has submitted that the consequence of adoption with respect to paragraph section 11 and 12 has been considered.
Now let's kindly come to the play.
His argument is that the relationship was not severed.
Let's come.
Plaintiffs.
The suit is nomenclature is partition suit. A partition can only be done, or a share can be asked for in two conditions. Firstly, if he is a sharer in the property, if two joint properties are purchased together by two persons, then only a person can claim partition in the suit or the share in the suit property. Now, the Dwarika Prasad Bhagat was adopted son. His status becomes the son of Mankumari. Now, as per the Hindu Succession Act, section 15 deals with the succession of intestate of a female. That who will now get property of a female who dies intestate.
Then it will go back to her family. It will go back to her family.
No, if a Hindu female dies intestate, it will devolve upon the class of years that has been given in the section 15 and 16 of the Hindu Succession Act. taken 15 years.
Why do you want to travel to this?
Pardon?
यहाँ जाने की जरूरत है?
ये इसलिए बता रहे हैं ना, यदि हम उनके लड़के एक बार हो गए मान कुमारी के, तो उसका प्रॉपर्टी केवल हम ही ले सकते हैं एज अ वे ऑफ इनहेरिटेंस.
Yes.
ये इनका कहना है कि वो साथ में रहते एक्टेड अपॉन था, तो वो नहीं होगा इसमें.
You see, once an adopted son,
Yes, status of a separate. Yes.
it is he is as good as a
So,
natural
therefore-
son.
and
He is as
therefore-
good as a natural son.
Therefore, this partition suit itself was a bad in the eye of law. I am just showing to your lordship that this partition suit should not have been entertained by the court below itself, because he was not the son of the Mankumari, or he could not devolve share in the property of Mankumari in this
No,
manner.
suppose Mankumari dies intestate. Right?
Yes.
Then under such circumstances, the property she having come to the family, her property will devolve upon the heirs of her husband.
No, not in that manner. This is what the difference in the section 16 says. So that यही हम आपको दिखाना चाह रहे थे. Firstly, upon the sons and the daughters and the husband.
Yes, sons daughters तो है नहीं.
So he is the adopted son now. द्वारका प्रसाद भगत is the adopted son.
अरे
now.
adopted son है तो सारी कहानी खत्म.
Yes, Lord. Just
लेकिन अगर नहीं है तो
नहीं होता तब कौन देखा जाता.
नहीं होता तो क्या होगा?
हम खाली का
अगर ये adopted son नहीं डील करते हैं,
Yes, Lord.
अगर ये इनका आर्गुमेंट मान लेते हैं that he is not the adopted son, it has been declared that
I
he is
was
the
just-
adoption is
I
bad
was
in the eyes.
Just showing that the partition suit itself was not maintainable. Therefore, because he was not any.
देखिए अपना ना point of law से मत digress करिए. We are not in a academic discussion, not really required. जितना point of law है बस उसी पर बहस करिए.
Now, Lord, they also relied upon a agreement.
That agreement is not the subject matter.
Yes, they have not placed it.
That
Because
agreement has been not
has-
accepted.
Has not been
by-
accepted by the.
That is not the subject matter.
One of the contention they have raised, not in the court below, that the expenses were made by this.
It's irrelevant.
That is irrelevant because the.
It's irrelevant. No argument has been advanced.
Yes,
Please
ma'am.
don't digress from
Yes,
whatever
ma'am.
they have argued. You just respond to whatever
But
they
the
have
only
argued.
response is that the Dwarka Prasad Bhagat, once adopted, is the son of Mankumari. He devolved the property, and it cannot be shared between with the plaintiff in this case in any manner.
The learned counsel for the respondent has submitted that the adoption was valid, and therefore the property devolved upon the adopted son of Mankumari, namely Dwarka Prasad, and the plaintiff, the defendant, the plaintiff in the present case had no right to seek partition with respect to the property. He has further submitted that otherwise also, as per the compromise, a portion was to go to क्या नाम है उसका?
Bhagavad Prasad.
Bhagavad Prasad Bhagat. And the plaintiff is not claiming through Bhagavad Prasad. उसके through तो claim ही नहीं कर रहे. Plaintiff is not claiming through Bhagavad Prasad. That's it.
And performing any last rites and other things.
He has submitted that mere
under the eye
performance
of
of
law does not give any
mere
right.
performance of last rite of his biological father does not annul the adoption of Dwarka Prasad by Mankumar. इनका यही argument.
So, response there. The first argument was that 6 years is calculated to challenge the validity, and once an adoption has been made, it must be declared in. So, matter the suit for validity is concerned. The title suit was instituted in the year 1947.
That we have, according to you, it has already been declared invalid. बस बात करता मैं फिर क्या फिर limitation का क्या काम?
The legal sanctity also safeguards under section 11, 12 or whatever contained in the Hindu Adoption Act would not be applicable. That is my solution.
In response, the learned counsel for the appellant has submitted that in the earlier title suit read with the compromise, the adoption was already held to be invalid.
And my lord, एक argument आया था that there were other properties of Kumari also. तो उसको safeguard करने के लिए ये challenge किया गया. So that is not the case in the written statement. That is not the case. They have not covered anything with regard to other properties and फिर भागवत प्रसाद accepting it कि हमको half share से I will be satisfied. That is not the case.
The learned counsel has also submitted that the arguments advanced on behalf of the respondents by referring to the judgment passed in the earlier title suit has nothing to do in the present case, inasmuch as it is not the case of the respondents that the property has nothing to do in this case, and the respondents have to stick to the written statement filed in the plate. अबेटमेंट पे क्या बोले?
एक चीज पे और वही हम लिखा हुआ था अबेटमेंट का लिखा हुआ इशू एक चीज और खाली इनका प्लेंट का ये एडमिट करते हैं कि अडॉप्शन हुआ था और हम उसको एडमिट किए हैं अपने रिटन स्टेटमेंट में यस अडॉप्शन वाज डन सो इट इज एडमिशन व्हिच नाउ दे कैन नॉट से दैट इट वाज अ इनवैलिड अडॉप्शन एक ये बात है प्लेंट में बोले अडॉप्शन है हम एडमिट किए हैं अडॉप्शन दैट्स ऑल सो नाउ दे कैन नॉट चैलेंज इट अडॉप्शन इज इनवैलिड
The learned counsel, उससे उन्हीं के submission, the learned counsel for the respondents has submitted that the plaintiff pleaded that there was an adoption and the same fact stood admitted by the defendant, and therefore there is no question of challenging the validity of adoption in the present proceedings which is arising out of the partitions. Okay?
Now, effect of abatement has been dealt in the judgment 2019-11 SCC 787.
What is it?
Now, Order 22 will force CPC based on that where within the time limited by law, no application is made to increase legal representatives of a deceased defendant. The suit shall abate as against the deceased defendant. This rule does not provide that by the omission to increase legal representatives of a defendant, the suit will abate as a whole. If the interests of the co-defendants are separate, as in the case of co-owners, the suit will abate only as regards the particulars interest of the deceased party. In such a situation, the question of the abatement of appeal in its entirety that has arisen in this case depends upon general principles. If the case is of such a nature that the absence of legal representative of the deceased respondent prevents the court from hearing the appeal as against the other respondent, and the appeal abates in court. So this is the principle held by the Supreme Court.
Referring to paragraph.
It's paragraph number 13 and 14. Paragraph 12, sorry. Paragraph 12.
On the point of adoption, the learned counsel for the respondents has, on the point of abatement, the learned counsel for the respondents has referred to paragraph 12 of the judgment passed by the Honorable Supreme Court, reportedly bracket 2019, bracket close 11, SCC 787, and has submitted that the effect of abatement has been duly dealt with in the same judgment. So, submission क्या है? ये तो आपने खाली
So now the 1D, the appeal has abated against 1D. So now his interest remains unattended by any other legal representative. So now if 1D gets his complete share in the property of Man Kumari, the others cannot be prevented from getting that share in the property of Man Kumari. The other, now the subsisting representatives who are presently now in the appeal.
The learned counsel submits that the proceeding having abated in connection with respondent number 1 bracket D, who is one of the substituted heirs of Dwarka Prasad Bhagat. Therefore, the right with respect to respondent number 1D has attained finality. And right of the other legal heirs and successors of Dwarka Prasad Bhagat who are on record, that cannot be affected. And therefore the entire appeal has abated. आपको क्या बोलना? Abatement.
Commercial abatement would not occur as sought relief against Dwarka Prasad. There will be no half addition. So the facts of the case would not occur as a whole. It would not.
The learned counsel for the applicant in response has submitted that the non-substitution of respondent number 1D has no bearing in the present case, as the case was filed against Dwarka Prasad Bhagat, and it is his right title and interest with respect to the suit property which was under challenge. And his estate is duly represented by the other respondents who have been substituted during the pendency of this case. That's all. Arguments concluded. Judgment is reserved. Post for judgment on 27th can next year. January 26 or on any other date as may be fixed, whichever is it.
इसके 31 को कर दिया जाए
21 को क्या है?
तो माटी रस्ते में क्या की
31 तारीख सैटरडे है सर।
मैं उसके बाद
एक दिन पहले कर देते हैं 29।
in fact as a Gandhiite I don't like
29 तारीख कर देते
doing hard कोई भी चीज इसको हम नहीं चाहते
आरटीएस डे के दिन तो हमको लगता है हम लोग को ज्यादा काम करना चाहिए
हाँ
to achieve the dream of our
yes
father
yes
of nation.
yes I am a devotee of Mahatma Gandhi
वो वाला जो judgment है ना 19 आपने citation सही दिया है ना?
Yes.
हाँ
Yes.
1911 SCC 787
Yes.
इसका एक कॉपी आपको चाहिए इन दोनों के साथ वो काम ही कर रहे थे इसमें राकेश जी उनके पास भेज दीजिए फाइल आधा काम किया नेक्स्ट वो जजमेंट सबको इसमें चाहिए इसमें नेक्स्ट क्वेश्चन चाहिए
ठीक Item 2 second appeal 88 of 1984.
Lawsuit is this last for legal lawsuit. Substitution of for the respondent is going on. Date number against the respondent for the lawsuit. it has already been abated. Albuni, Malguneswar Makor. Rest as may be substituted also.
No, that I have already passed in order.
To discuss the council for the respondent was already on record.
Sorry?
Council for the respondents are they are already on record. And he has not given the details of the date. He was responsible for the
You
intimation.
see, respondent number 1A,
No, sir. They are the main contesting party.
1A, 1B, and 4 I have rejected.
Hello. They are the main contesting party.
Respondent number 4 का तो अबेटमेंट हुआ है 8/9/97 में. इसके बाद कुछ नहीं हुआ. और ये जो इनका डेथ हुआ है 2013 में. क्या किया था सर? कुछ नहीं किया.
पता नहीं था.
किसका क्या चीज का नहीं पता. रिस्पॉन्डेंट नंबर 4 का डेथ तो रिकॉर्ड पे आ गया ना.
No,
97 में आ गया दैट ही हैज एक्सपायर्ड. आप कहते हैं 88 में उनका डेथ हुआ. जस्ट इमेजिन. वेयर आर यू? नहीं सर. आप अपना केस आगे करो. The entire appeal has abated because of this. Is that correct or not correct? Please.
Here also there is citation also. Order cannot be passed on the death for you.
क्या citation आप cite कर रहे हो? अबेट कर दिया proceeding ना?
नहीं. मैं लोग देखिए आपको. Judgment cannot be passed to get the date.
So therefore the proceeding has abated. अब क्या?
At that time, both the councils they are appeal also, and they have not communicated.
If they have not communicated legal reason. And this respondent number 4 never even filed a written statement. उसका क्या relevance है? कोई relevance नहीं. A person who does not file a written statement,
Then one and two.
he's not a contesting party.
One and two blocks. They are.
1 and 2 का तो उसका 1 and 2 died by.
They are the contesting party.
They are contesting parties,
No, no.
certainly.
They are the main party.
You place your case. Case placed. You argue your case. आप आर्ग्यू करेंगे अपना केस. सब्सटैंटिव क्वेश्चन ऑफ लॉ बना हुआ है. अबेटमेंट पर भी सुनेंगे. पहले सब्सटैंटिव क्वेश्चन क्या है केस, किसका क्या राइट था, किसका कितना स्टेक्स था, ये सब देखना पड़ेगा ना अबेटमेंट में. कौन रिटन स्टेटमेंट फाइल किया नहीं किया. अ पर्सन हु डिड नॉट फाइल रिटन स्टेटमेंट आल्सो, उसका डेथ का क्या रेलेवेंस. ही डिड नॉट बी सब्स्टिट्यूटेड, isn't it? A person who did not file a written statement.
No. Right. Then also you can engage the senior also. तो senior
अब क्या करना है आपको? इतना दिन से ये चल रहा है। पिछले
the
दिन
orders in the
ऑर्डर से नहीं है, अब हो गया। तो पिछला डेट में इनके आपके सामने ही तो ऑर्डर किए थे कि हम लोग सुनेंगे इस केस को फाइनली।
एक senior रखने में प्रोजेक्ट
कल करें,
कल नहीं
परसों करें।
वन वीक मंडे को आने से करते हैं असल में तो कुछ है ही नहीं मेमो
Last time के ऑर्डर के अनुसार you have to argue as to whether the appeal has abated as a whole. अगर if the appeal has abated as a whole, there is no point deciding anything. If the appeal has not abated as a whole, then only there is further question of deciding the substantial difference.
अब तो डॉक्यूमेंट है नहीं देयर इज नो डॉक्यूमेंट इन माय विटनेस वगैरह कुछ नहीं
क्या चीज़ नहीं है?
विटनेसेस का प्रिंट का
तो हमारे पास भी नहीं है ना सर, हम पढ़ रहे हैं, आप भी पढ़िए, आपको मना किया पढ़ने के लिए।
एसीआर काम करेंगे
एनसीआर हम भी तो अपने घर में ले जाकर एक रात पहले पढ़ते हैं, आपके पास सातों दिन है पढ़ने के लिए। आप यहाँ पे बैठिए और पढ़िए, हम उसका स्कैन कॉपी भी नहीं दे सकते क्योंकि पूरी तरह से फट चुका है। स्कैन करने भेजेंगे तो जो बचा हुआ है वो भी फट जाएगा। और ये भी जब भी आप यहाँ पे देखेंगे हमारा कोई आदमी आपके साथ रहेगा असिस्ट करने के लिए, नहीं तो पूरा पेज फट जाएगा। आप अपना रिकॉर्ड देखिए। अब अगला दिन में ये सीनियर नहीं बोलेंगे कि बस अब हमको रिकॉर्ड करना है।
नहीं मंडे को रखिए
ऐसा नहीं होना चाहिए। किनको एंगेज कर रहे हैं, किसी को सोचे एंगेज करने की?
बात करो
हाँ,
जिनको करेंगे
जिनको भी करेंगे, लेकिन अगला डेट में आपके सीनियर खड़ा होकर ये नहीं बोले कि हम तो पहली बार खड़े हो रहे हैं, आपको कुछ पता नहीं।
नहीं पर आज ही बोलेंगे आज ही
तो उनको बोलिएगा कि अपना रिकॉर्ड जो देखा है देख लें, ठीक है? लेकिन पहला बहस अबेटमेंट पर ही। दिस इज आवर लास्ट ऑर्डर। इफ द प्रोसीडिंग हैज अबेटेड देयर इज नो पॉइंट डिसाइडिंग एनीथिंग एल्स। सब्स्टिट्यूशन इसीलिए बाकी का कुछ लोगों का तो हमने रिजेक्ट कर दिया सब्स्टिट्यूशन, लेकिन बाकी लोगों पर ऑर्डर इसलिए नहीं किया क्योंकि अगर उनका हम सब्स्टिट्यूशन रिजेक्ट कर दिए तो बाकी तो अबेट हो गया प्रोसीडिंग, तो बाकी लोगों को नोटिस करके सब्स्टिट्यूट करके क्या करेंगे? देयर इज नो पॉइंट। at the request of the learned counsel for the appellant, who has submitted that he has to engage a senior counsel to argue this case. The matter is directed to be posted for final disposal on Monday by way of last incumbents. उस दिन अगर आप लोग टाइम मांगेंगे ना तो हम इसमें 1 लाख रुपए का कॉस्ट ही करेंगे, बता दे रहे हैं। 84 का मैटर को लेके हम लोग 26 में नहीं जाना था, 2026 में एंटर नहीं करना चाहते इस रिकॉर्ड को लेकर, ठीक है।
For finals to item 3, first appeal 138 of 2023.
Pursuant to the previous order, I appear for assignment number 1 and 2, Deputy Commissioner of the copy was served yesterday.
Copy was served yesterday.
The copy of the petition, the memo of appeal. It's a suit for specific performance. I also have to seek instructions on the point of transferability of the password.
The notice was already validly served upon respondent number 1 and 2. So you cannot say that a copy has been served to you for the first time.
It was appearance of
We don't bother about it. Notices were issued to you. It was served way back as on 20. It is recorded in 28/6/24. We will not give you time. If you want time, you have to pay cost. Are you ready for the cost?
this suit for specific purposes.
Yes. I was the plaintiff and my suit was dismissed. Suit for specific performance was dismissed by the Cabinet Trial Court. In this case, my lord is wherever my lord the contesting the other defendant number 3 who died during the pendency of this suit, my lord, their legal error has been substituted and they have been given notice by way of gazette publication in the newspaper, and that my lord has accepted. So now my lord, only defendant number respondent number state is representing on behalf of the defendant. Now my lord, kindly see the case of the plaintiff. In a nutshell, just giving brief manner, because this is the first appeal. I must, my lord, place my lord plain and written statement filed by the state. Now, agreement pursuant to the agreement of the year 2013, I was to pay rupees 25 lakhs. It was in cash.
What is the date of agreement?
My lord, the first agreement is my lord 7/3/2023.
Exhibit.
This is exhibit, my lord. This is exhibit 1. This is exhibit 1. Yes.
Entered into between.
Entered into between the plaintiff and my lord the defendant, the original defendant number 3, Ranjit Lahiri. Now there was a condition, this was a condition that only upon payment of rupees 25 lakhs, fresh agreement to sale will be executed. So 25 lakhs through check were paid to defendant number, original defendant number 3, and thereafter fresh agreement to sale was executed on 7/12/2014.
What is the date?
This is my lord 7/12/2014.
No, exhibit 1 is 7/3/23.
Yes, this was the first agreement, and there was a specific condition that the purchaser will have to first pay 25 lakhs.
That's right. But the subsequent agreement is you are telling 2014.
13 का पहला था तो
13 नहीं 23
नहीं 13
हाँ subsequent agreement is
14
7
17/12/2014
17 12 14 exhibit
one by one
between the same persons.
between the same.
Does it acknowledge the payment of rupees 25 lakhs?
Yes, because it was
What
I'm
is the
sure
remaining consideration?
the remaining total consideration was 76 lakhs.
So remaining would be 15
Yes, yes. Now subsequent thereto, we are giving a break.
Why is the state partnering this way?
Because property is a khas मामला. So
तो इसका agreement of sale कैसे होगा?
oh, होगा because only because this is
Did
a
you take any permission from the state?
Yes, yes. So it was a specific condition that permission is to be taken from the state authority, sanctioned because it is necessary, and there that's why it was agreement to sale. That's why it was
The sanction was granted.
sanction was granted. There were two properties. For one property, sanction was granted. Schedule 1 the second part है, and for so far schedule 1 property, it was under process at the time of agreement, and subsequently during pendency, it has been granted. But since we have not been, we only got knowledge that the property has been sold to someone else now, and nothing has been informed. They immediately
The
informed.
cause of action in connection with the second property is subsequent. It happened during the pendency of
Yes,
the
but that was a condition, and there was a specific stipulation in the.
Maybe,
Yes.
but the cause of action to file the suit was second part of the property did not arise at the time of filing of the suit.
At the time because
Because the permission was not there.
the permission was well, the only part was on the plaintiff. There was condition in the agreement to say that we have to take steps. Now we taken steps, and the entire formality up to the office of the commissioner of Hazaribagh, it was completed. Matter was sent to the revenue secretary. Now it was to be informed to the vendor, but natural because I was not a party. Now when third party has been given possession over the two property, cause of action has arisen. So we have specifically, I will come to the point also. We have given a specific statement to that effect that these were the conditions, and this was the specific date when I got one of the third party is in possession over this property. We immediately approached the defendant number 3, given legal notice. Now apart from that matter, apart from 25 lakh rupees payment, subsequent thereto rupees 23 lakhs through check has been received. 23 lakhs.
When?
Yes.
When was it paid? When during the pendency of the suit or
No, prior. So we during the subsistence of the agreement to sale.
Pursuant to the agreement of sale, you were never put in possession.
No, we were because position only on the basis of, even if I would be, law will not recognize me
The law will recognize it certainly.
because this was.
Law recognizes possession.
नहीं लेकिन 53A आ जाता ना हुजूर कोल्ड की हुई अगर रजिस्टर्ड हो जाता तो हो जाता. Anyway, now we paid. Now very interesting, everything had been exhibited. Exhibit the my bank statement and the subsequent payment after 14 agreement by which the vendor, the defendant number 3 was paid. Everything was exhibited. Now the landed trial court dismissed my suit on the ground that first, that the property was lease was not renewed, so it could not be transferred. And second, that subsequent payment was made through third party at the instance of the plaintiff. So it cannot be said that plaintiff has paid the amount. Now I exhibited the certificate issued by the bank which was given to me. And in the evidence, the remaining 23 lakhs checks, which was deposited and cash, apart from 25, the remaining pays.
You issued check to whom?
Dividend number 3, 25
It
lakhs.
was your check.
No, it was my firm check. It was my firm check.
Firm, it's a company or it's a partnership firm or it's a simple
It's a
sister
simple
firm?
firm, proprietorship firm.
Proprietorship.
Yes, and in the evidence we have stated that हम उनके जो है firm से हम वो पैसा दें. And my lord, apart from even if they are not there, the learned trial court has taken a very new my lord approach, just ignoring. My lord is well aware that the provision contained in section 2D of the Contract Act. What is consideration? Consideration made by the promisor himself or by any person at the desire of the provision. My lord is well aware. So on that count, my suit could not be dismissed.
In absence of renewal of lease,
Yes.
what can be sold?
In absence, my lord.
And what is your right? And why should a court execute a sale deed
Yes.
in connection with a
My lord
property?
is- My lord is.
In connection with the property, because it is an equitable jurisdiction also. And
Yes.
court has to see whether the court is going to pass an order which is properly executable or not.
Correct.
Then under such circumstances, if the lease deed itself is, the Khasman lease itself is not renewed,
Yes.
right? Then under such circumstances, how the court will execute the sale deed?
Yes, my lord is correct. Now, had it been the approach of the trial court, perhaps this first appeal would not have been done. There were two
We will-
Well,
These issues will arise before
Yes,
the
yes,
court.
that's why I just wanted to answer. Two suit property was there, and for one there was already delivered. In the agreement itself, there was two property. One, for with respect to one property, the perpetual lease, this lease should not be, my lord is well aware with the Khasman lease. This perpetual lease was for with respect to one scheduled property, it was already renewed prior to institution of the suit.
Because that lease was renewed,
Yes.
but the other lease was not renewed.
So at best, I am taking my worst. So I had no case. So far as not renewed, I will show from the judgment how it was valid. Even if it is assumed that it was not valid, court has to see. So court could not dismiss my agreement, my payment, my relief with respect to the entire suit, for which there was subsisting lease, there perpetual lease, lessee was there, everything was there, it was pleading there, their admission also there. Then for that suit property, my suit cannot be dismissed. तब तो वो बात आता नहीं, क्योंकि वो तो लीज था.
For first part, right?
Well, I will show that.
Just a moment.
Yes.
For first part,
Yes.
lease was renewed.
Second part it was renewed.
Lease not renewed for first part.
First part holding number 2 होल्डिंग था 242 और 243 243 से ये रिन्यू.
एक second. First part is 243.
First part is 242.
242 holding.
Yes.
Lease was not renewed,
Yes.
but permission was granted.
No, परमिशन अगर ग्रांट हो जाता तो
Permission नहीं grant.
परमिशन उसमें वो अंडर प्रोसेस था. अंडर प्रोसेस था, कमिश्नर के यहाँ से भेज दिया गया. माय लॉर्ड इज वेल अवेयर कि फाइनल जो सैंक्शन होता है वो रेवेन्यू सेक्रेटरी पास करते हैं आफ्टर रिकमेंड.
Permission was under process.
Yes.
Second part,
Second part was renewed.
okay. Permission refused.
नहीं सब कुछ हो गया था.
Permission was also under process.
परमिशन वाज अंडर also.
And then during the pendency, the permission was granted.
Well, it appears from from the records.
You
Because
must
they
have
should have-
exhibited.
नहीं
Permission अगर exhibit में
नहीं।
आपका ex parte चल रहा है proceeding.
हाँ नहीं वो फर्स्ट पार्ट के लिए नहीं, वो उस पे रिकॉर्ड नहीं आया, इसलिए हम बोल रहे हैं बात को.
Permission दोनों में से किसी का भी नहीं हुआ.
परमिशन दोनों में दोने का नहीं है.
Permission अगर नहीं आएगा तो कैसे आपको specific performance?
यही तो लॉ क्या है यही देखना है.
बताइए ना.
लॉ है डायरेक्ट जजमेंट ऑफ ऑनरेबल अपेक्स कोर्ट राइट फ्रॉम 1971.
As per the agreement, the sale deed was to be executed upon getting the permission, or not?
No.
There was no such condition in
No,
the
sir,
agreement.
everything was to be performed by me.
Whosoever has to perform.
Yes, yes.
But there was a stipulation in the agreement that it will be executed after getting the permission.
Yes, yes.
So that is a condition of the agreement.
The condition of the agreement. So if it was under process, the defendant could not have any right to refuse.
If it was under process, the cause of action to get specific performance of contract did not mature on the date of filing the suit.
नहीं, जब अगर मेरे प्रॉपर्टी जिस प्रॉपर्टी को हमको ट्रांसफर करना है उस प्रॉपर्टी पे अगर इनको अला करके पोजीशन में दे देंगे और इनको सेल डीड कोई कर देगा आई वांट
उनको सेल डीड हो गया था.
सेल डीड नहीं.
In anticipation आप इंजंक्शन तो मान
नहीं,
सकते हैं.
नहीं.
In anticipation on.
It was not anticipation. That's why I am also.
No. You see,
This is
the cause of action to file the specific performance of contract, right, did not mature.
एक एग्रीमेंट हुआ. I respect to submit. एक एग्रीमेंट हुआ. इस एग्रीमेंट पे हमको राइट दिया गया इस प्रॉपर्टी पे. इस प्रॉपर्टी
आपको क्या राइट दिया गया? आपको ये राइट दिया गया कि हमारा परमिशन हो
नहीं,
जाएगा तो
पहला
आपको बेचना.
रिन्यूअल का सब काम कराएंगे. परमिशन का ये स्टेप लेंगे. अब ये सब प्रोसेस में है. अब इन द मीन टाइम एक थर्ड पर्सन को प्रॉपर्टी के पोजीशन में दे देते हैं. कंस्ट्रक्शन होने लगता है. नाउ व्हाट प्लेंटिफ हैज अ राइट.
Plaintiff has different rights and different kind of relief you can see.
That relief I also saw as a relief number 2. I understood that. So that was also saw. लेकिन अगर ऐसा लॉ होता कि नहीं सैंक्शन इनको लेना था, सैंक्शन करा करके क्योंकि होता अल्टीमेटली सैंक्शन आर टू बी ग्रांटेड टू द वेंडर. केवल एक जजमेंट देखा जाए उसके बाद का भी जजमेंट है. फैक्ट पे हम लोग आ जाएंगे उसके बाद. तो ऐसे केसेस में ये स्पेसिफिक डायरेक्शन इशू कर होता है कि नहीं यू गेट द परमिशन मतलब अप टू ऑनरेबल अपेक्स कोर्ट पास द मतलब हेड इन सेटल द मैंडेट दैट vendor is required to get permission and after permission you sell it even if sale has been transferred to third party. अगर देखेंगे पायलट सारा इस डिसीजन को और उसके लाइट में जो एग्जीक्यूटेड डॉक्यूमेंट कंडक्ट इनका देखिए सब पैसा ले लिए मैं 50 ये तो इन राइटिंग है. उसके अलावा 3 चेक लिए कि हम जिसमें रजिस्ट्रेशन करेंगे. कैश को तो प्रूव नहीं कर सकते जब तक वो आकर के क्रॉस एग्जामिन नहीं हो. दे अपीयर्ड सब्सिक्वेंटली दे अपीयर्ड जब एक्स पार्टी हो गया फैग एंड में हुआ उनके आगे वो डब्ल्यूएस भी फाइल किए उनके अगेंस्ट में एक्सेप्ट नहीं हुआ. माय लॉर्ड द कंडक्ट माय लॉर्ड इज वेल अवेयर कि स्पेसिफिक रिलीफ एक्ट में कंडक्ट भी देखना है. दे लेफ्ट दिस सूट from record my lord can get it although it is not noted down in the impugned judgment my lord but from the record my lord can get it that they appeared the vendor appeared but did not dare to come to the dock to face the court. एक WS फाइल करके छोड़ दिए एक्सेप्ट नहीं हुआ इट वाज नॉट चेक.
जिनको इन्होंने पोजीशन दिया उसको तो आप पार्टी नहीं बनाए.
पार्टी बनाने की कोई जरूरत नहीं था. पार्टी बनाने की कोई जरूरत नहीं था. हमारा राइट तो चूंकि फिर हो जाता वही बात कि हमारा राइट तो केवल लिमिटेड है उस एग्रीमेंट टू सेल के. इसलिए माय लॉर्ड वाज करेक्ट कि नहीं आपके पास एक राइट था कि आप उसको रोकते इंजंक्शन का ऑर्डर लेते. किसी भी तरह का कोई डील होता या किसी तरह का राइट थर्ड पार्टी के फेवर में होता तो आप उसको यस दैट लीफ वाज आउट. सारा पैसा ले लिए हैं उसके बाद किसी और आदमी को पोजीशन में दे देंगे. Equitable, my lord is well aware. I need not to explain. We file also one application calling the court कि आप उसका रिकॉर्ड सब मंगवा लीजिए. ये कस्टोडियल स्टेट अफेयर my lord it was in their custody. Entire document it could have been exhibited. My lord, a person, my lord, is also well aware.
State did not file any written statement.
Filed written statement, my lord, but record has not been filed purposely. And my lord is well aware a person who is in possession of the best evidence does not produce adverse inference has to be withdrawn. Why they have not produced? Now, defendant number 3, taking the center of defendant number 1, contested the suit in spite of filing of written statement, did not dare to come to the dock, my lord, to face the court.
There's a background, so we are plaintiff mistake.
Yes, my lord, I am deeply aware.
Plaintiff is. How many witnesses were examined from your end?
तो plaintiff की तरफ से 2 और बाकी टोटल जो एग्जीक्यूटेड डॉक्यूमेंट है माय लॉर्ड कैन गेट इट फ्रॉम पैराग्राफ 9 इंटरनल पेज 11 ऑफ द ट्रायल कोर्ट जजमेंट.
This is the first agreement.
Yes.
Second agreement. Legal notice. What is this notice?
ये नोटिस 2 नोटिस है माय लॉर्ड. Yes. One notice actually first suit was filed before this suit, and in that suit section 82 का उनका exemption का application भी फाइल हुआ. राइट, इमरजेंट है, देखिए ऐसा ऐसा है, थर्ड पार्टी नाउ कमिंग इन पोजीशन, दे आर एक्सरसाइजिंग. तो भाई इनको तुरंत हमको सूट को मेरा एक्सेप्ट कर लिया. 82 में मेरा पिटीशन अलाउ है. 82 का पिटीशन अलाउ नहीं हुआ. प्लेंट वाज रिटर्न. देयर आफ्टर इट वाज डायरेक्टेड नो यू फर्स्ट फाइल अ लीगल नोटिस. तो हम लोग प्लेंट एक्सेप्ट कर लिए, रिटर्न हुआ. तो उसके बाद वी सर्व अ लीगल नोटिस अंडर सेक्शन 82. कंप्लायंस हो गया, स्टैट्यूटरी पीरियड ऑफ लिमिटेशन 2 मंथ का एक्सपायर हो गया. देन वी फाइल दिस सूट मैटर, दैट इज द सूट. This is exhibit 2, section 86. And second was that मतलब this was the
पहले वाला लीगल नोटिस 29.
ये वाला तो 16 वाला जो है वो उसको फोटोकॉपी है जो डिफेंडेंट नंबर 3 को भेजे थे. Perhaps my friend was correct कि नहीं, इसमें हम लोग इंस्ट्रक्शन ले लेते हैं कि रिन्यूअल हो गया है, क्योंकि अगर रिन्यूअल हो गया है देन दे हैव नो ऑप्शन.
इसमें इंस्ट्रक्शन का
कोई कंस्ट्रक्शन है नहीं. आई थिंक
ये जितना जितना बैंक स्टेटमेंट है,
हाँ.
दिस इज रिगार्डिंग पेमेंट.
यस यस रिगार्डिंग तो 48 लाख को प्रूव करता है.
ये जो एग्जिबिट नंबर सीरियल नंबर 9 में जो है,
जी,
व्हाट इज द डेट ऑफ फाइलिंग दिस?
ये है मतलब सूट है 16 का मतलब
59.
वो जो स्टेटमेंट पे जा रहा है 17 का जो डेट है ना, उस पे मतलब पहली टेक नोट ऑफ इट. वो जो स्टेटमेंट 15 से है, जो पेमेंट पहले प्रायर टू इंस्टीट्यूशन है ना, वो पूरा स्टेटमेंट निकाल के विद सर्टिफिकेट एग्जीबिट कराया गया है, इसलिए वो स्टेटमेंट का डेटा है. एग्जीबिट से हम लोग रेफर करते हैं कि किस किस डेट.
नहीं नहीं, ये जो है
एग्जीबिट 9
एग्जिबिट 8 जो है
8
ना,
जी,
दिस इज 17/12. दिस इज प्रायर टू सूट.
प्रायर टू
8 ये बैंक स्टेटमेंट 10/6/13 का है.
7 भी है.
5 to 8
5 to 8
is prior to institution,
प्रायर टू 8 and 5 to
and 9 and 10 is post institution.
नहीं 9 में देखा जाएगा 30/10/2015 है जो फर्स्ट डेट है, उससे दिखा देंगे कि ये प्रायर टू इंस्टीट्यूशन. इसमें क्योंकि पूरा स्टेटमेंट कहाँ से कहाँ तक का है वो टेकिंग डाउन है, वो हम लोग रेफर करके दिखा देंगे कि प्रायर टू इंस्टीट्यूशन और उसमें कितना पे.
issues क्या क्या बने?
Yes, the issues were there. Paragraph.
7.
Yes.
What is the para 7?
The present suit is brought by the plaintiff, initiated on the basis of presentation of the claim on 16/10/2025, in which after issuance of the summons, the defendant appeared in the suit and contested the suit by filing their written statement. On the basis of the pleading of the plaintiff and defendant, the following issues have been framed in the suit on 16/11/2025.
So defendants, all of them they contested the suit.
Defendant number 1, what has happened? Defendant number 1 and 2, they are the state, they contested, they filed written statement. Now defendant number 3 subsequently appeared when suit was proceeded ex parte. WS was filed, it is in the record, not in the judgment. I may be permitted to submit also. Now they filed written statement, it was not accepted, they did not challenge it, they just watching the suit.
Defendant number 3's written statement was not taken on record.
Not taken on record. My lord, I have the copy, it was filed.
What were the issues framed?
The issues framed was whether the written suit is maintainable in its present form in law and in fact. Issue number 2, whether the suit is bad for misdemeanor and non-misdemeanor present parties, whether there is any cause of action for the present suit, whether the suit is bad as per provision of the Specific Relief Act 1963, whether there is any cause of action in the present suit, whether the suit is properly valued, whether the defendant number 3 had any right to exclude any agreement in respect of the A and
7 and 8 was taken up first.
Yes.
What is the finding in this?
Yes. Paragraph 8.
Yes.
The plaintiff has instituted the suit for seeking a preliminary decree in favor of the plaintiff regarding a specific performance of the agreement to sell dated 17/12/2014 by directing the defendant to exclude the selling and delivery of actual possession of the suit land in favor of the plaintiff against the payment of balance and consideration for by which the registration of sale be executed through process of the court, and defendant also admitted the fact the agreement in this regard is suit is fixed by a provision of a specific performance act.
बाकी तो general provision है. Where is the finding?
Now,
Abandonment and to avoid and to readiness and willingness has to be there.
Madam, finding will come from page number 15, there is page 15 number lowest level.
Page number 14. In this case. In this case.
Yes. In this case, the plaintiff
Yes.
served a legal notice dated 29/2016 upon the deceased defendant number 3 Ranjit Lahiri and substituted defendant number 3 A.D. Lekha Lahiri and Rajit Lahiri, showing his willingness to pay the balance consideration amount in respect of the agreement dated 17/12/2014 and asking the defendant to exclude the registration of sale of the suit. The plaintiff has now come to know that the defendant is negotiating with different persons to sell the land at his stated and higher price than that with which the defendant had agreed with the plaintiff with a view to defendant the claim of that the defendant had subsequently performed his part of contract with the plaintiff out of greed of an amount of on account of extraordinary escalation in the price of the suit land, that the plaintiff had performed his part of contract by paying the advance money of rupees 50 lakhs paid by check and rupees 8 lakhs paid by cash to the defendant. The agreement to sell dated such and such does not envisage any other step to be taken by the plaintiff. There is a distinction between the readiness and willingness to perform the contract, and both ingredients are necessary for the relief of a specific performance. In such and such, cited by such and such, this court said that there was a difference between readiness and willingness to perform a contract. While readiness means the capacity of the plaintiff to perform the contract, which would include his financial position, willingness relates to the conduct of the plaintiff. The same view was taken by the court in case such and such. In Sardar,
In this suit, nature,
in this suit, the plaintiff has contended that he was ready and willing to perform his part of contract. In this regard, firstly, I will go through the willingness of or conduct of the plaintiff that the agreement was executed between both the parties on 17/12/2014, and for non-exclusion of the said agreement, plaintiff sent the legal notice to defendant number 3 on 29/7/2016 and defendant number 1 on 17/8/2017 under section 80 CPC. After perusal of both legal notices, it appears that both notices are sent to the defendant after lapse of approximately 2 years from the date of agreement of sale, and I think this conduct is not shows the willingness of the plaintiff to purchase this suit land. However, in order to subsequent his claim for readiness, the plaintiff has produced the bank statement, which are marked as exhibit number 3 to 3/4, and stated by the plaintiff that he was ready to perform his duty and consideration amount was in his account. After perusal of the said bank statement, exhibit number 3 dated 3/4/2013, exhibit number 3/1 dated 4/5/2013, exhibit number 3/2 dated 10/6/2013, and exhibit number 3/3 dated 17/12/2014, it appears that all the same statement of the bank account is in the name of plaintiff Mahavir Tiwari, and all the statements are on or before the date of agreement of sale dated 17/12/2014. After perusal of exhibit number 3/4 bank statement dated 30/10/2015 से 16/5/2017, it's found that this statement is the name of the Mahalakshmi Milcon Private Limited and not in the name of the plaintiff. In this regard, there are two issues to evidence that if the plaintiff is the proprietor of the said firm, and if the said firm is entered into agreement for sale dated 17/12/2014. For the first issue, there is no any documentary evidence came on the record that the plaintiff is proprietor of the said firm, and secondly, if presumption that plaintiff is proprietor of the said firm, the agreement dated such and such was executed in persona between the plaintiff and Mahavir Tiwari, not on behalf of Mrs. Mahalakshmi Milcon Private Limited, and the amount of the said firm cannot be considered as plaintiff fund. Further, plaintiff could not satisfy the court that why plaintiff has produced the bank statement so and so, exhibit 3 to 3/3, which is in his name, before the agreement of sale dated 17/12/2014, and why after the date of agreement he produced the bank statement, exhibit number 3/4, Lakshmi Milcon Private Limited. Therefore, it was the duty of the plaintiff to oppose the defendant having prepared for the execution of the sale deed in respect of the suit property. There has been no evidence available on the record which may go on to suggest that the plaintiff took any step in furtherance of execution and registration of the suit property. As a matter of fact, the plaintiff himself has been found to be not performing his part of contract for which the defendant cannot be blamed, even though the plaintiff has not taken any step to do the same. Plaintiff was waiting for renewal of the lease and sent the legal notice after approximately 2 years and 4 months. The conduct of the plaintiff shows that he was just performed his duty as formal, and he could not prove his readiness and willingness. It is settled law that for relief of the specific performance of plaintiff has to prove that all along, until the final decision of the suit, he was ready and willing to perform his part of the contract. It is the bounden duty of the plaintiff to prove his readiness and willingness by adducing evidence. The crucial facet has to be determined by considering all circumstances, including availability of funds and mere statement or government. In the plaint of readiness and willingness would not suffice. The plaintiff has brought the suit on the basis of an agreement dated 17/12/2014 that the consideration amount of the aforesaid land was fixed at an rupees 75 lakh, out of which the plaintiff paid the defendant number 3 rupees 48 lakhs rupees by check. Meanwhile, before execution of the agreement to sale on 17/12/2014 as requested by the defendant number 3, the plaintiff paid rupees 8 lakhs in cash to the defendant number 3 at Kanadi in Hajaribaग on 15/12/2014. Moreover, the plaintiff had handed over checks bearing number such and such, such and such, and such and such of rupees 15 lakhs as a security to the owner at the time of execution of registration of power of attorney in favor of the plaintiff after the renewal of the scheduled delay. That it would not be out of place to mention that the aforesaid land and premises stands renewed from 1/4/2008 to 31/3/2038 in the name of Ajit Bari, defendant number 3, and Ajit Bari, who is the own brother of defendant number 3. However, the building renewal is under process of renewal. In order to decide issue number 7 and 8, firstly, I would like to go through the agreement dated 17/12/2014, exhibit number 1 by 1, alleged to be entered on behalf of both the parties. In said agreement, both the parties are agreed for transfer half share of class number 9 of the Schedule A and Schedule B property maintained as plain, mentioned as plain. The said property was got by plaintiff through a building lease by government estate which was in the process of renewal from 1/4/2008 to 31/3/2008 of this, and the plaintiff entered into agreement for sale with plaintiff from 17/12/2014 without renewal of the said lease. Further, it also appears that as per rules 9 and 21 of Bihar Government State Manual 1953 provides that settlement/transfer is permissible only with the prior approval of the state government. Plaintiff had not produced any sheet of paper who shows that the defendant number 3 was got prior permission from the state for transferring the said Khasmal land, or not produced any document. Also shows that he was applied for state permission. PW1 plaintiff himself admitted the fact in his statement and also supported by the PW2. Witnesses are admitted that before the lease transfer, prior permission of the state is necessary. Further, plaintiff has also found the document later 167 class 1 such and such. Therefore, later was detailed. In the letter, it is clearly direction. May I read the report? पत्रांक से प्रेषक मोतीलाल लड़का सरकार के उप सचिव सेवा में उपायुक्त ग्राम कोर्रा बागवानी पट्टा होल्डिंग नंबर 243 प्लॉट नंबर 58 पूर्व रकबा 2 एकड़ 4 एकड़ भूमि का श्री के नाम लीज नवीकरण के संबंध में महाशय निर्देशानुसार उपयुक्त विषय अपर समाहर्ता हजारीबाग के पत्रा 108/8 दिनांक 23/13 के द्वारा आयुक्त उत्तरी छोटा नागपुर प्रमंडल हजारीबाग को बेसिक अभिलेख संख्या 47/07-08 मूल रूप से समय संलग्न करते हुए करना है कि ग्राम कोर्रा बागवानी पट्टा होल्डिंग नंबर 243 प्लॉट नंबर 58/166 रकबा 2 एकड़ 40 भूमि का दिनांक 1/4/2008 से 31/3/2038 तक के लिए श्री अभिजीत लाहिड़ी एवं श्री रंजीत लाहिड़ी पिता स्वर्गीय डॉक्टर आदित्य लाहिड़ी के नाम निम्नलिखित शर्तों के अधीन लीज नवीकरण की स्वीकृति दी है। लीजधारी को सलामी के रूप में 5,78,381 रुपया भू राजस्व प्राप्ति शेष 0029 के अंतर्गत कोषागार में जमा करना होगा। दिनांक 1/4/2008 से वार्षिक लगान रुपये जितना अलावे शेष लीज रेंट इंडेक्स पत्र में निर्धारित करके अनुमोदन होगा। प्रश्नगत भूमि मात्र बागवानी नियोजन के लिए रहेगा। खास महल स्टेट मैनुअल में निहित प्रावधान एवं सरकार द्वारा समय समय पर निर्देश का पालन करना होगा। इसकी प्रतिलिपि अभिजीत लाहिरी, रंजीत लाहिरी, दिस इज इम्पोर्टेंट बैलेट फॉर माई सब्सिक्वेंट। अभिजीत लाहिरी, रंजीत लाहिरी, पिता स्वर्गीय स्वयं को निर्धारित सलामी की राशि के चालान के माध्यम से कोषागार में जमा कर चालान की प्रति कराए गए प्रस्तुत। Therefore, in the letter, it is clearly direction by the state slash renewal authority in clause C that the said land was used only for the purpose of Bagmani. It means the DG lessee cannot the said property for the other purpose like that.
ये प्रश्नगत भूमि मात्र बागवानी प्रयोजन के लिए नहीं।
बागवानी हम भी करते हैं। सेल ट्रांसफर कैसे नहीं हो सकता है? मतलब बताइए, परपेचुअल ट्रांसफर है, परपेचुअल लेसी है, with the condition of transfer with prior permission. How? Why can it cannot be so?
The point is that there is no permission.
The point is not. Point is that my lord, that permission is to be taken by the vendor. Permission, no, even if it is not taken, my lord, I am taking. That's why, my lord, I always argue against me. Now, the worst case was that permission was to be taken, and then it could be held maintained. Then we have to see only the provision. My lord, I will see argue subsequently. Then we have to see what is the law. My lord, since 1970-71, it has been well settled that if any sanction is mandatory, then in the case of a specific performance of contract, then vendor is required, court always direct the vendor, you go, take permission and then transfer. क्योंकि तो एग्रीमेंट टू सेल है, ट्रांसफर नहीं है। सेल होता तब ट्रांसफर, सेल का 5 ही कोड है जो ट्रांसफर ऑफ प्रॉपर्टी एक्ट होता है। एग्रीमेंट टू सेल से मेरा कोई राइट नहीं आता है एक्सेप्ट मेरा वेंडर के खिलाफ, कोई राइट नहीं आता। सारा चीज को माइलॉर्ड हैज ऑब्जर्व, माइलॉर्ड सारा पेमेंट को ये कर रहा है कि नहीं, इनका कंडक्ट ही नहीं ठीक है, पैसा ही नहीं दिए, महालक्ष्मी बिल कौन काहे दे दिया, सेक्शन 2 दे दिया है माइलॉर्ड को, उसको कुछ
कंपनी,
हम माइलॉर्ड
it's a company, private limited.
प्राइवेट लिमिटेड लिख रहे हैं माइलॉर्ड, बिकॉज़ इट वाज नॉट एग्जीक्यूटेड।
उसका तो कोई डॉक्यूमेंट भी नहीं आया है, उसका क्या स्टेटस से नहीं आया है, आपका क्या रिलेशनशिप है उसके साथ नहीं
वो
आया।
एविडेंस ओरल देखिए ना, उसके बाद माइलॉर्ड बिल
ओरल एविडेंस से कैसे ये डिसाइड होगा इन एक्स पार्टी प्रोसीडिंग? व्हाट इज योर रिलेशनशिप विद?
बता रहे हैं, जब माइलॉर्ड इज वेल अवेयर कि जब बैंक स्टेटमेंट दिया जाता है अकाउंट का सर्टिफिकेट के साथ, तो किसी ऑथराइज्ड पर्सन को ही नहीं देगा। अगर हम चले जाएंगे
नहीं, ऐसा नहीं, ये नहीं बोल सकते।
ना, मेरा ओरल एविडेंस में ये है, मेरा ओरल एविडेंस में ये है। और इवन इफ माय लॉर्ड, सपोज इट, आई विल कम टू दैट आल्सो, बट इवन इफ इट इज, माय लॉर्ड इज वेल अवेयर।
No, you see the point is that not only this whether you have paid or not, for what it was paid.
No, I must say this must not come because I already paid.
No, therefore you see there is a firm who is making payment,
Yes.
right? There is an individual person who is making payment.
Yes.
When it comes to the firm,
Yes.
right? How do you know that this payment was made only for this purpose? ये कहाँ से पता चलेगा? भाई दो आदमी के बीच में बहुत तरह के पेमेंट्स हो सकते हैं। How do you link this payment to for this particular purpose with respect to your firm? जिसका आप ना कोई कागज लगाए हैं, ना आप लिखे हैं कि आप उसके पार्टनरशिप फॉर्म में, कौन सा डॉक्यूमेंट है जो बता रहा है कि आप उसके पार्टनरशिप फॉर्म में? अब किसी का भी कोई भी ट्रांजैक्शन उठा के अगर आप बैंक स्टेटमेंट प्रोड्यूस कर देंगे तो इट विल नॉट रिलेट टू द ट्रांजैक्शन।
My lord,
You have to not only prove payment but also you have to prove that this payment was for this particular purpose. How will you prove it?
now,
आपका कौन सा डॉक्यूमेंट है जो आपको इस फॉर्म से लिंक करता है?
my lord, I beg to support one thing.
और आपका ये प्लेंट में लिखे है कि आपकी कंपनी है, आपने इस कंपनी के थ्रू पेमेंट किया है?
नहीं, प्लेट में तो हम एविडेंस को डिस्कस नहीं किए हैं, लेकिन
एविडेंस
पेमेंट की है।
एविडेंस का पेमेंट के देखिए, पेमेंट किसके थ्रू किए हैं? इट इज अ मैटर ऑफ फैक्ट। द रीजन इज दैट एनी पेमेंट मेड बाय एनीबॉडी will not be attributable to this particular deal.
एक मिनट माय लॉर्ड, हम यहाँ पे इसको कल मार्क करके हम आगे चलेंगे, डिस्कस करेंगे। अगर जब कोई डॉक्यूमेंट में टेक लीव,
Yes, yes,
now if the document bank statement was content was being proved by the plaintiff. Now the plaintiff while proving the same, the plaintiff specifically says in his evidence कि उनके फर्म उनके खाते में पर्याप्त पैसे थे जिसका प्रमाण उनके फर्म मां लक्ष्मी बिल्डकॉन प्राइवेट लिमिटेड द्वारा परिलक्षित होता है जिसका रजिस्ट्रेशन पेपर इसके साथ में संलग्न है। इसकी संपुष्टि के लिए वादी के द्वारा अपनी फर्म का बैंक स्टेटमेंट न्यायालय में दाखिल कर रहा हूँ।
रजिस्ट्रेशन कहाँ है? रजिस्ट्रेशन कहाँ है?
रजिस्ट्रेशन नहीं है, इस अपनी फर्म का बैंक स्टेटमेंट न्यायालय
बैंक स्टेटमेंट फॉर्म का किसी भी पर्टिकुलर आदमी के साथ बहुत तरह के ट्रांजैक्शंस
है।
हाउ विल यू लिंक दीस टू? इट वाज सर्टेनली रिक्वायर्ड टू बी प्लीडेड कि आपने फर्म के नाम से चेक दिया था फॉर दिस पर्टिकुलर ट्रांजैक्शन। ये तो
pleading is required to. My lord, I suppose, my lord, if it was required, then my lord, since my lord is equity court exercising equity jurisdiction. Now, my lord, whether it should not be seen that whether plaintiff was ready by making payment.
No, that will
First
whether we want to take this particular payment as payment against the agreement of sale. If it is a payment against the agreement of sale, then only the question of readiness and willingness of balance payment
So
comes.
now why this point of evidence has not been brought? So this point, now well, apart from that, this point has to be cross-examined.
You see, this
Any point of evidence, well, if I just for my sake, if I am submitting in examination in chief that I have done something and something, whether this point should not be.
See, had you stated that you have made this payment yourself, that is not your case in your plate. That you have issued certain checks or some payment was made.
That is there, madam. That is there. How check number is pleaded, madam? Check number is pleaded, madam.
Check number drawn on
Minor.
whose account is something which is
Minor.
also equally important.
Minor.
Check number से क्या होगा?
Check number payment in favor of defendant number 3. This has been pleaded.
Check has been exhibited.
Check तो कैश
चेक एग्जिबिट हुआ है कि नहीं हुआ है? आप
बैंक को दे दिए ये केस
बैंकर नहीं आएंगे एग्जिबिट करने के लिए।
मतलब बैंक स्टेटमेंट
The reason is the check would have disclosed that you have issued this check. In what capacity?
I am not being able to explain better. What my case is कि मैंने जो 48 लाख का चेक दिया वो 48 लाख रुपया डिफेंडेंट नंबर 3 ने इनकैश करा। अब ये हमारे ये जो इनकैश करा जो चेक नंबर था ये प्लीडिंग में है। केवल मां में कौन का जो नाम है माइलॉर्ड आई मस्ट फेयरली एक्सेप्ट, लेकिन जो माइलॉर्ड ने कहा कि आपने चेक नंबर को प्लीड किया माइलॉर्ड डेट पे प्लीडिंग में है।
चेक नंबर drawn on whose account?
ड्रॉन ऑन नहीं लिखा हुआ लेकिन डिफेंडेंट नंबर 3 के पेमेंट को करना था वो है प्लेट में दिखा देते Can we see my paragraph 5 to 6, 5 and 6 of the play? Very मुझे ऐसा नहीं है। अगर हमको भी लगा अगर पेमेंट नहीं हुआ 76 लाख ले लिया माइलॉर्ड का पेमेंट करना है 48 लाख से कैश
and then you make this payment as security.
वो कौन 15 लाख रिमेनिंग 50 लाख के अलावा सबका चेक नंबर है माइलॉर्ड 50 लाख के अलावा माइलॉर्ड कंडक्ट को देखना है। अब प्रिपॉन्डरेंस ऑफ प्रोबेबिलिटी में इतना हाई डिग्री ऑफ प्रूफ में माइलॉर्ड हम लोग तो मर जाएंगे। पैसा भी ले लिया हुजूर आप पेमेंट किसी को रजिस्ट्री भी कर देगा तब तो कभी कर भी नहीं। आप हुजूर हम दिखाएंगे माइलॉर्ड को रिकॉर्ड से कि वो डब्ल्यूएस फाइल किए आकर के कह देते कि कोई पेमेंट हमको नहीं, गवाही में चढ़ जाए।
In the impugned judgment, I am seeing it from here only as of now. Para number 6. पैरा नंबर 5 बता रहा है आपका,
जी
राइट? नहीं, ये इनपुट है, प्लेट सॉरी,
प्लेन
प्लेट
बोले बोले प्लेन
प्लेट
का पैराग्राफ 5
पैरा
that after due negotiation and consultation between the plaintiff and defendant, the consideration amount of the aforesaid land was fixed at rupees 76 lakhs. Accordingly, both the plaintiff and defendant agreed to prepare an instrument to this effect. On 7/3/2013, the plaintiff and the defendant number 3 executed an instrument putting in writing the consideration amount of the land at rupees 76 lakh out of rupees 76 lakh rupees. The plaintiff issued check bearing number 691,862 and 691,863 drawn on State Bank of India Hazaribagh branch for rupees 9 lakhs in favor of Ranjit Lahiri, defendant number 3, and rupees 8 lakhs in favor of Srimati Rekha Lahiri, wife of Ranjit Lahiri, and check number 19964 drawn on Bank of India Hazaribagh branch for rupees 8 lakhs in favor of Arijit Lahiri, son of Ranjit Lahiri, all dated 29/3/2013, all to be cleared on or before 29/4/2013. Whereafter, the defendant number 3 shall execute an agreement to sale of the aforesaid land in favor of the plaintiff. The further पच्चीस हो गया, 9 8 17 8 25, जो पैरा 5 में था 25 लाख वाला, तो 9 लाख और 8 17 लाख, 9 8 17 और 8 25 लाख। चेक नंबर देख लीजिए सब अलग अलग। उसके बाद आ जाइए पैरा पहली पैरा 6, that further as demanded by the defendant number 3, plaintiff paid to him 25 more lakhs in the following manner. Because we minor policy check का नंबर which date और किसके फेवर में,
एग्जिबिट
इसका एग्जिबिट किस है?
Exhibit 1 is the first agreement.
Yes.
Or the exhibit,
One,
second agreement is
1 by 1 14 है। तो 17 12 14।
आप हमको बताइए तो कब कितना पेमेंट किया? आपका सेकेंड एग्रीमेंट में तो है 50 lakhs was received. उसके अलावा आपने 3 चेक दिया था, ये चेक भी एनकैश हो गया?
नहीं, वो सिक्योरिटी चेक था at the time of सर रजिस्ट्रेशन
तो वो एनकैश नहीं हो।
नहीं हुए।
अच्छा, उसके अलावा 50 लाख के बाद आप क्या
वो
करेंगे?
8 लाख रुपया कैश का जो बात हो रहा है,
It is over and above 50 lakhs or
ओवर एंड ओवर
58 lakhs.
और 2 लाख टू 50 और 58 लाख और 15 लाख का उधर
Security. तो वो तो सब एक्सपायर हो गया होगा।
हम दे देंगे। अगर ड्राफ्ट बना करके जो माय लॉर्ड कोर्ट जो दिस सॉल्यूशन कोर्ट विल से आई विल।
तो 58 plus 15 कितना हुआ? 73. Total was how much?
76।
76. इसमें clause है that it has been reviewed for a period of 30 years from 1/4/78 to 31/3/2008. And for renewal of both the leases for next 30 years, that is 1/4/2008 to 31/3/2008, on the basis of joint application of the lessees, time and time are pending in lease renewal cases. Right? इसमें 75 lakhs लिखा है total consideration.
लेकिन 76 हम जोड़े थे इसीलिए शुरू से 76 बोले।
लेकिन एग्रीमेंट में
75 रिन्यूअल वाला जो बात है जो पेज नंबर थर्ड पेज में जो है एंड ऑफ शेड्यूल का उसमें लिखा हुआ है योर जॉब लीज हैज बीन रिन्यूड टिल दोस नॉट दिस सबसे लोवेस्ट है।
It has been mentioned that the lease renewal of the Schedule 1 is pending approval. And orchard lease has been renewed. Building lease renewal is pending. उसका क्या मतलब है?
बिल्डिंग उसमें घर वर बना है
बना हुआ था तो बिल्डिंग वाला pending. After both the parties have signed the sale agreement, it is the duty of the second party to pursue with the task involved in the lease renewal of the property under Schedule 1. This also means that the expenses incurred during the approval process, government fees, etc. has to be borne by the second party. The balance of 10 lakhs will be paid by the second party upon renewal. The title of transfer will not commence unless full payment is made. The possession will also be given after full payment. So at the time of issuance of notice also you are conscious of the fact that the renewal has not been done. What is the finding of the learned trial court ultimately? What is the reason for refusal to grant you the relief?
लिटरेचर के बाद तो हम लोग पढ़ लेते हैं।
However,
However, the plaintiff and defendant exclude the agreement dated 17/12/2014 before the any renewal and prior permission from the state, and as per agreement, the parties were agreed on the condition that after the renewal of lease by the government means that on agreement the contract is for future transaction and uncertain conduct which is unlawful and illegal. In the eye of law, agreement that do not currently exist but are agreed to potentially exist in the future are also legally void unless all items in the agreement are actually agreed. Section 29 of the
इसी ground पे ही dismiss. That is the sole ground for dismissal. कौन सा judgment आप चाहिए?
ये है 71 Supreme Court page 1
Did not even pray for an alternative relief.
मतलब
refund?
पेमेंट टोटल हो चुका था, आप कर लेते हैं।
आप रिफंड का प्रेयर नहीं किए?
नहीं किए क्योंकि टोटल पैसा उस समय का दिया हुआ है। अब अगर रिफंड भी होगा उतना पैसा से मेन पर्पस था कि हमको प्रॉपर्टी मिल जाए, अदरवाइज इट कुड हैव बीन पेड।
ऑल्टरनेटिव रिलीफ आपने नहीं प्रे
नहीं प्रे किया, हाँ, इसलिए दैट्स व्हाई इट वाज नॉट पेड। ये लग रहा था कि हम लोग को टोटल सब्सटेंशियली पार्ट कंडक्ट कर दिए हैं, और भी कुछ रिक्वायरमेंट होगा तो वो
बिना उस प्रेयर के हम आपको पैसा दे भी नहीं सकते।
नहीं किसी दे सकते नहीं दे सकते। हालांकि इक्विटेबल रिलीफ हम जजमेंट
एक्स पार्टी है ना, एक्स पार्टी है ना,
हाँ एक्स पार्टी
बहुत मुश्किल है,
मुश्किल हो जाएगा एक्सक्लूजन में बिल्कुल
बहुत मुश्किल है। एक्स पार्टी प्रोसीडिंग अगर साथ में पार्टी रहता तो बात दूसरा था, अगर प्रोसीडिंग एक्स पार्टी है तो बहुत मुश्किल है कि हम आपको रिफंड का प्रेयर करें। नहीं सर, आप रिफंड के लिए मनी सूट नहीं खाई?
नहीं फॉर्मली सूट मतलब ये डिसीजन केस में कंडक्ट ऑफ प्लेंटिफ इज वेरी वेल
नहीं रेडीनेस एंड विलिंगनेस जब कंडीशन प्रेसिडेंट ही नहीं सैटिस्फाई हुआ तो रेडीनेस
एक ही ना मतलब एक ही ना
नहीं,
सूट प्रॉपर्टी
दो सूट प्रॉपर्टी है ना,
हाँ,
एक का तो आया ही नहीं, एक का भी पार्ट है ना,
हाँ।
सिर्फ ऑर्चर्ड का है, घर का नहीं,
हाँ घर का
तो कैसे उसको सेपरेबल करेंगे?
नहीं दोनों अलग अलग है, शेड्यूल अलग है, बाउंड्री अलग है, होल्डिंग नंबर अलग है, इसलिए माय लॉर्ड हैज टेकन डाउन तो देखे हैं होल्डिंग नंबर माय लॉर्ड अलग अलग।
इसमें जो बोला है ना कि शेड्यूल 1 जैसे
होल्डिंग नंबर
एक सेकंड आप हमको बताइए शेड्यूल ऑफ प्रॉपर्टी
देखिए
शेड्यूल ए में आइए, शेड्यूल ए
अलग अलग होल्डिंग नंबर है, बाउंड्री भी देखते हैं हमने एक गलत को देखते
नहीं जो आपका एग्रीमेंट है दोनों के लिए अलग अलग कंसिडरेशन अमाउंट है,
नहीं वो ज्वाइंट है,
तो कैसे इसको सेवर करेंगे?
ज्वाइंट
कैसे करेंगे सेवर? शो मी सम मेथड कि भाई हम इसको सेग्रीगेट करके इसका इतना कर देते हैं,
नहीं
पर एकड़ के हिसाब से भी नहीं है रेट।
नहीं हम आई वांट डिफरेंट डिमांड आई विल कम since this is first appeal but my submission is that if law is that court while exercising equity jurisdiction can direct the owner to get the permission and then execute that the thing would not be required क्योंकि ट्रायल कोर्ट तो बोले कि परमिशन चाहिए, परमिशन मिला नहीं है। अब अगर ऑनरेबल अपेक्स कोर्ट बोल रहे हैं कि नहीं ऐसे केसेस में जहां प्रायर परमिशन लेना है और परमिशन नहीं हुई या परमिशन हुआ प्रॉपर्टी ट्रांसफर हो गया तो भाई कोर्ट के पास क्या जुरिस्डिक्शन। ऐसी केसेस में सुप्रीम कोर्ट ने कहा 71 से ये सेटल्ड हो गया, 2006 का भी जजमेंट है, कोर्ट ने कहा कि नहीं अगर परमिशन नहीं हुआ तो आप परमिशन लीजिए और परमिशन ले करके जिसके पेपर में एग्रीमेंट किए हैं उसके शेल्डिंग रजिस्टर कीजिए, बैलेंस कंसीडर। हम इस पॉइंट पर हैं मैडम।
You see, the relief was only sought in connection with defense number 3.
हाँ हाँ तो उसमें दोनों है मतलब प्रेगरी में है वो कवर है वो कवर that ways to pass a decree in favor of the plaintiff and against the defendant for a specific performance of contract from say such and such. पर वो कोई बहुत बड़ा इशू नहीं है, वो देर
ये जजमेंट बताइए कि in cases where a suit for specific performances of contract is filed without getting the prior permission as required.
ये 71 जो सुप्रीम कोर्ट है ये इसका मेरा 6
इसको फैक्ट पढ़िए करने से।
तो फैक्ट तो मैंने कल
कल के हम लोग पढ़ेंगे, कल करेंगे, 1:30 बज गया है, सेकेंड हाफ तो ऑर्डर 41 वाला है।
खाली कल ही कर परसों कर
नहीं प्लीज ऐसा
कल सेकंड हमें ऑपरेशन करना है सुसूति का अगर हम विवाद नहीं वहाँ का आएगा कैटरेक्ट का ऑपरेशन करना है भले आगे पीछे लेट हो जाएगा तो फिर माइनर कोई कहेगा तो
परसों रख दें।
ना इसीलिए बोले कोई इशू नहीं परसों रखें sometimes when we are bound by our home
नहीं कोई जरूरी
क्या
नहीं।
करें प्रॉब्लम नहीं इसलिए
आपको
उनको इतना रेडी है डिसीजन
क्या होता है ना कि अगर एक फाइल खुल जाता है तो दूसरा फाइल शुरू करने में हमको बहुत दिक्कत
उनको
होती
कोई दिक्कत नहीं फिर पढ़ना होगा फिर
है। पर पढ़ना नहीं, वो फैक्ट्स कंफ्यूज होने लगता है।
हम समझते हैं
फिर क्वेश्चंस कभी दूसरे फाइल का क्वेश्चन नहीं,
नहीं
नहीं,
बात
नहीं,
नहीं हम लोग तो देखते हैं एक महीने बाद वाला कि सब ठीक है
परसों हम लोग कुछ रखे हैं क्या? 10:30 बजे करेंगे।
जी सर
The hearing of the case has commenced. As the court time is over, post this case for further argument on day after tomorrow to be taken up as first case at 10:30. Let this matter be treated as part.
ठीक है